live.
Yes, we have a quorum.
Excellent. All right, great. Well, welcome everyone.
And
Good
we're on
afternoon.
live.
Today is Wednesday.
We're on live streaming.
Yep. All right. Good afternoon, everyone. We are live. If you didn't know, it is Wednesday, January 19th. Today we have 10 bills on the docket, and we'll start off with Senator Kagan with Senate Bill 57. We'll move on to Senator Kagan, Senate Bill 83. We'll jump to Senator Bailey, 68. Then we'll go to 71, 22, 151, 44, 49, 31, and then we'll end up with Vice Chair Wallstreicher at Senate Bill 26. I've been told that the system, for the people that are viewing on the YouTube end of things, the system that notifies which bill is up is not working right now. So I'll just announce the bill, and if folks could pay attention when they're watching, that'd be great. Otherwise, we'll keep you apprised in the chat. So without further ado, we are Senate Bill 57. Senator Kagan, I'll ask to unmute you. There you are. Welcome. The floor is yours.
Thank you very much, Mr. Chairman. For the record, I'm Cheryl Kagan, very proud to be the senator for Gaithersburg and Rockville. As much as that, I am also super proud for the last 4 years to have chaired the Next Generation 911 Commission. As you all have heard, but maybe folks watching at home don't know, 3 people died in my district when 911 has failed. And with help from this committee and its members, we have put Maryland at the forefront nationally of moving towards Next Generation 911. Today I'll be presenting 2 bills. And I want to flag for you first a couple of things. First off, Josh Prado, one of your counsels, did a great job as my partner on these bills. And so I just want to publicly thank him. And my witnesses and others who have submitted testimony have also been remarkable partners. I want to mention that this is a different legislative proposal than you've had in the past. Again, thanks to Josh, thanks to the vice chair and advocates. Rather than bringing you one bill with swatting and TDOS, DDoS, and I will define those as one bill, we've separated and clarified those. So Senate Bill 57 is about swatting. And swatting is when somebody maliciously and with ill intent calls or contacts 911 and makes a false accusation that can result in, certainly at the very least, unnecessary use of resources of a public safety facility. At the worst, it can result in significant injury or death. We basically in Maryland have insufficient penalties in the opinion of this commission. Unanimously, the commission has endorsed this bill in order to make sure that folks know that we mean business. Now, is swatting really a thing? And I assure you that it is. This is not a hypothetical problem. So it has happened nationally with celebrities, including Clint Eastwood, Ashton Kutcher, Justin Bieber, Tom Cruise, Simon Cowell, and here in Maryland, Wolf Blitzer and a journalist, Leonard Pitts, are 2 examples of significant public people who have been swatting. That means that someone called and said, so with Wolf Blitzer, police rushed in with more than a dozen heavily armed officers to the Bethesda home of the CNN anchor. And the call had been a hoax. They had indicated that the caller was Wolf Blitzer himself and that he had just shot his wife, neither of which were true. This bill would just increase if the folks were dispatched, if police were dispatched and nothing else happened, it would increase the penalties to 3 years and up to a $5,000 fine. If serious bodily injury or death happens, which has happened, the penalty would be increased to up to 5 years and or a fine of up to $25,000. I want to mention that it that, again, this has happened. It's not only can it be racially motivated, which happens too often, it can also be very oddly of video gamers. And there was an incident in Kansas where a 25-year-old was playing video games online. He was frustrated with his opponent, swatted one of his opponents, made a false police report, and it ended up that his opponent was shot and killed. So I have great witnesses today, and I just want to mention that Jack Markey, who's one of my witnesses, and the new chair of the 911 board and the head of the Frederick County 911 Center is going to mention an amendment, and he caught what all of us missed despite our reading the bill. And there's a one-word amendment that just changes from telephone to equipment, and it is a totally great catch, and I endorse his one-word amendment. With that, I'm really delighted to have support from Acting Secretary Russell Strickland, the new secretary of the new department, the Maryland Department of Emergency Management, who also understands that this is a critically important bill. There is other written testimony that I encourage you to review. My three witnesses are Bill Ferretti, Kevin Canale of Maryland Association of Counties, and Jack Markey. And with that, Mr. Chairman, I'm happy to take any questions, or I'm happy to wait, whatever is your preference. Thank you for your time and attention. I urge a favorable report on Senate Bill 57 with a one-word amendment.
Excellent. Thank you very much, Senator Kagan. We'll do the entire panel first, and we'll take questions at the end. So we'll go next to Mr. Ferretti. Mr. Ferretti, you're up. The floor is yours.
Good afternoon, Mr. Chairman. Bill Ferretti, coming to you from North Carolina. I am the former 911 director for Montgomery County. I retired in 2020. I also had the honor and privilege to serve on the commission to advance Next Gen 911 across Maryland for 2 years. And then after my retirement this past year, continued to advise the commission. These topics of one that I've testified in previous years before the Senate, the Maryland Senate. Swatting, as the senator said, it happens. It fortunately doesn't get a lot of press because we try not to create copycats in the public safety industry. But the consequences can be severe. It's not just the person at the other end of the call where armed officers, as the senator gave an example, enter a home. They're traveling at fast rates of speed, obviously doing an emergency response to that address. And anytime you put public safety responders in an emergency response, there is unfortunately the opportunity for harm to come. Currently, the laws that we believe are insufficient. Penalties right now would amount to no more than misdemeanors. And therefore, and as we live in a very large world integrated across state lines, even if you could identify the suspect, which we can, those misdemeanors are not extraditable. So part of this bill is to raise the penalties for these crimes when the target is a public safety agency or 911 center to that of a felony, so that we can have successful prosecutions. Thank you.
And thank you very much, Mr. Ferretti. And next we'll move on to Mr. Canale. Hey, there you are, Kevin.
Thank you, Mr. Chair and members of the committee. Kevin Canale here on behalf of the Maryland Association of Counties in strong support of Senate Bill 57. You have my written testimony, and I think the senator and Mr. Ferretti did a great job of walking through the bill and why this bill is so important. But counties are here because we run 911 at the local level. And we know that this law will strengthen the state laws to protect 911 centers from malicious threats that disrupt emergency communications and jeopardize public safety. So swatting is absolutely an issue. And by weaponizing 911, swatting places not only the first responders and civilians in danger, the person that's being swatted, but it also drains limited public safety resources. And I think Mr. Ferretti alluded to the fact that when you have first responders, rushing to a scene, that also can put the community in danger. So there's a lot of issues here that need to be addressed. And we think Maryland should absolutely hold people accountable for this. And we need to strengthen the laws to do that. So by protecting 911 centers against these threats and attacks and dangerous swatting incidents, this bill will absolutely enhance public safety in Maryland and in our local communities. And we'd ask this committee to issue a favorable report on Senate Bill 57.
Excellent. Thank you very much. All right. Next, we'll move on to Mr. Markey. You're up.
Thank you, Chairman Smith. My name is Jack Markey. I'm the Director of Emergency Management for Frederick County, Maryland. Since 2008, I've served as a member of the Maryland 911 Board, and for the last 4 years, have served as a member of the Commission to Advance Next Generation 911 across Maryland. I appreciate the opportunity to speak with you today. Local governments, as Mr. Canale mentioned, are working tirelessly to try to protect our 911 systems from traditional threats as well as emerging threats, swatting being one of them. As we take our own technical protective actions to reduce the likelihood of these events having an adverse impact on 911, we also need to take parallel action to change the laws so that we can deter people from committing those acts and, when necessary, prosecute them. My friendly amendment, I appreciate Senator Kagan accepting the amendment. The goal there was to make sure we don't have any loopholes where someone who may be texting to 911 in an abusive manner doesn't get a get out of jail free because they've done it from a computer or a gaming console or anything like that. So I ask your favorable support for this with the one noted amendment. Thank you.
All right. Thank you very much, Mr. Markey. With that, that concludes the testimony for Senate Bill 57. I'll open up to the committee for questions. All right. I see two questions. We'll start off with Senator Castley, and then we'll move over to Senator West. Senator Castley, you're up.
Thank you, Mr. Chairman. Really, for anybody on the panel, I'm trying to understand the bill a little bit. So I'm looking, I have a copy of it in front of me. I'm looking on page 2. So we get line 15, trying to compare the line 15 through 27 with the next section, lines 9-501. So it's really 3-804 with 9-501. And 3804 says you can't use these to make a call or send data to impair the functioning or to disrupt emergency response. And then the next section, 9-501, has to do with false statements.
Senator Castley, may I interrupt you for a moment?
Yeah.
I think you're on the wrong bill. I think you're in the next, we're in Senate Bill. We're on swatting and not TDOS. So we're in Senate Bill 57.
57.
That's what I'm looking at. It says Senate Bill 57.
Okay, just, I apologize. It sounded like you were talking about that. I apologize. For
No,
this.
Senate Bill 57, page 2. And it's just, it says 3-804 and 9-501. You see that? Sections. Look on line 7 says 3-804. And line 28 on page 2 says 9-501. It's amending the section. And so I'm just trying to understand at a really practical level here. 3-804, which is lines 15 on that amendment, talks about not using these things to impair the functioning or disrupt emergency response. And the next section, 9-501, has a false statement. I'm trying to understand the difference. I understand how if I call up and say somebody's doing something and they're not doing it, you have to dispatch fire trucks and ambulance and police, that's a false statement. That's pretty obvious what we're doing there. 3-804, I guess a false statement could impair the functioning, but I'm not sure. What can you explain 3-804 a little bit? What are we getting at with that one that's not a false statement?
Bill or Jack, do you want to respond based on your on the ground experience?
And
Go
I
ahead,
think I'm
you-
unmuted.
You are, yes.
Okay.
Okay.
So I think the big difference is really just a nuance in the law, addressing two different areas, where 3-804 is addressing the equipment side of, if you will, the connection that's created in order to provide the information, where 9-501 is addressing the content of what's actually provided. it's really no more than that.
So just give me an example. How does somebody violate 3-804? Just give me a good example, or a typical example of how they would do that currently.
So 804 would be to actually use a telephone and they call, in most cases, they call a 10-digit number. Sometimes they call directly to 911, but often it's through a 10-digit backdoor number or the non-emergency number to a 911 center or to a police district station. And they'll say, given the example of the Wolf Blitzer situation, I just shot my wife and I'm holding a gun to my children. And, this is an ongoing, what I'll describe to you as a potential active shooter. There may or may not be some red flags, but nonetheless, law enforcement and public safety agencies have to take that seriously and have to respond. So they respond out. So the fact that, under 904, 3804, the violation is the fact that the method that was done was they used telecommunication facilities, equipment to make that phone call to provide that information. Under 9501, the fact that they provided the false information, the information itself, the contents, would then be a violation under 9501. The penalties are basically copied down one from the other.
Well, I'm not so sure. I mean, under 804, you get, I see, 3 years and 50. Okay. Yeah, I'm still not following, but maybe I'll hit it up with counsel or something later. I'm just not following the difference between the two sections. I mean, you could get, if I call and make a false statement and you have to dispatch people, I could get prosecuted under 3804 and get 25 or 5 years and $25,000. And then looks like me, for the very same set of facts, I could also be violating 9501 and double the punishment just for the one incident. So, but I won't belabor this, but I will need some explanation at some point. Thank you.
All right, excellent. We'll move on to Senator West. Are you still? Senator West may have had to jump off to do a hearing. Senator Kagan, we'll just follow up with you from Senator West.
Perfect.
All right, excellent. So with that concludes the hearing for Senate Bill 57. We'll now move on to Senate Bill 83. Senator Kagan, you're up.
Thank you, Mr. Chairman. 1 second. For the record, again, Cheryl Kagan, very proud to be the senator for Rockville and Gaithersburg and the chair of the Next Generation 911 Commission for the last 4 years with some of the most extraordinary public safety leaders I've ever worked with. I think my colleagues have all gotten copies of, and you're not going to be able to see this, of our 4th and final annual report, which is available publicly in lots of different places, including my website. I also want to recognize Senator Ed Riley, who was my steadfast and remarkable partner for the last 4 years. Delegate Michael Jackson, when he was in the House, was on the commission as well and has been supportive as a senator. The 2 delegates now on the commission are Delegate Sue Krebs and Delegate Terry Hill. And I just want to publicly recognize and thank them for their partnership and leadership on these public safety issues. Senate Bill 83 is about jamming phone lines or access to a 911 center electronically. And the problem, again, as in swatting, is not hypothetical. My friend and constituent who inspired my work on 911, Carl Henn, died after being struck by lightning during a freak thunderstorm because the 911 center was overloaded. Now, that was because real people were making real phone calls and having concerns or issues that they needed addressed. But what if someone had jammed the phone line, a bad actor, or kids who just thought it would be fun? A lot of times what it is a computer generated multiple phone calls or jamming it through emails, texts, or other methods, electronic methods of making sure that no one is going to be able to call and let them know that their baby isn't breathing, that grandma has a heart attack, is having a heart attack, that their house is on fire, or they've just been raped and the bad guy is running away. We need people to be able to have access. So first off, TDOS, the telephone denial of service, or DDoS, the digital denial of service, are the 2 things that, again, unlike last year, which kind of had them in the same bill as the swatting bill, this is now just the telephone and the digital jamming of our 911 centers. They are not currently outlawed and there aren't penalties, and they are happening. So I just want to again thank Secretary Russ Strickland, new acting secretary of the Maryland Department of Emergency Management, for his partnership and endorsement of this bill, as well as there's several others. We've got Baltimore City, Tania Reddick here, Barry Glassman, the county executive of Harford County has allowed the wonderful Randy Cunningham, who succeeded Bill Ferretti as chair of the Technology and Cybersecurity Subcommittee. He's here to testify. Frederick County, Jack Markey, and others have all submitted testimony, as well as, of course, our wonderful partners at the Maryland Association of Counties and many others. So I just want to flag that. I want to mention that this, again, is not a hypothetical. There are hacking and shutdowns that happen all the time. And I just want to also mention the clarifying amendment. There was one section of the bill that wasn't quite as precise as another section. And so I want to flag that. And thanks to Bill Ferretti for catching that. So it is just a clarifying and technical amendment that I support and endorse. And with that, I'm really going to let my three witnesses share their stories and their passion for making sure that we get this done this year. Thank you very much, Mr. Chairman. And again, happy to take questions afterwards.
Excellent. Thank you very much, Senator Kagan. So now we'll scramble over to Randall Cunningham. Get it? Scramble. I don't know. My name's Will Smith, so I can make these really bad dad jokes. So I've got Zoom fatigue just like everyone else. So just it's going to happen for the rest of the session. All right, Mr. Cunningham, you're up.
Good afternoon. Thank you. I get that a lot, so I'm okay with it. Good afternoon, committee members. My name is Randy Cunningham. I work for Harford County Emergency Services. I'm a technology manager for our 911 center and our emergency operations center. I would just like to provide some insight on Senate Bill 83 and why this bill is important to our operations of the PSAP, which is known as the Public Safety Answering Point, or 911 Center, as many of you know it as. With the advancement of next gen 911, we're going away from a lot of our older analog circuits, which are capable of being attacked and having TDOS, someone just dialing 911 over and over again. We're automating that system, but we're also entering the digital age, and we're putting in IP networks that will allow us to transfer those calls across state lines further than we can today, or throughout the whole state of Maryland more than we can today with our older systems. Along with that, even today in Maryland, if you're unable to place a 911 call, you can actually text 911 and we will answer you and get information from you and send help to you, all via a text message. In the future, you'll be able to send pictures and videos of suspects or a lot of information. But with all this technology comes the ability for, again, these bad actors to do harm, to send viruses, hackers easier to get into the system. We in our 911 community work every day and continue to work to enhance our networks, enhance our security. But as you can see, there's always someone out there in another country, in the United States, next door to you, that is trying to attack and do harm to our networks. So basically, this bill is just enhancing the existing law, helping to protect our 911 centers and prosecute those malicious actors if they do try to attack our networks, and hopefully unsuccessfully. But even if they do, we have that law there in order to prosecute those. That's pretty much it. Thank you.
Excellent. Thank you very much. And we'll now move. Thanks for having good humor on that one. All right, let's move over to Ms. Reddick. You are up next. There you
go. Sorry about that. Good afternoon. My name is Tania Reddick. Thank you for giving me the opportunity to be here and testify on a bill that will protect 911 centers in Maryland, thus protecting every resident and visitor. I am the 911 director of the City of Baltimore and will be speaking on behalf of the City of Baltimore's Public Safety Answering Point. Every minute of every day, our incredible 911 specialists put on their headsets, log into sophisticated computer systems, and protect our communities nonstop. Yes, I said sophisticated computer systems. In Maryland, we are 911 centers of the future. Call after call, mothers giving birth, car accidents, people trapped in fires, robberies, incident involving violence, and it goes on and on. The caller's voice, the connection, the data, the location, the software, the nearest paramedic. It's all computer networks, and we must protect these components as much as we protect the people. Baltimore City's 911 center was the victim of a cyber attack in 2018. While I can't go into specifics, I can confidently say that cyber attacks and the destructions of our vital computer systems at 911 places an enormous amount of stress on the 911 center and on 911 specialists taking emergency calls and protecting our communities. An attack can bring a center back 50 years, taking away important technology used to save lives. We never want this to happen to any center, ever. Again, we are the 911 centers of the future. Phone lines are equipments of the past, and you once protected them. Computers and networks are the equipment of the future, and we must protect these with everything we have. Therefore, I recommend the Senate Bill 83 move forward to help us to continue to save lives. Thank you.
Excellent. Thank you very much. Thanks, Ms. Reddick. We'll now move on to Mr. Canali. You're up.
Thank you, Mr. Chairman and members of the committee. Kevin Canali here on behalf of the Maryland Association of Counties in strong support of Senate Bill 83. Again, I think that the panelists and the senator have done an excellent job of sort of walking through the bill and why it's necessary. But generally, you've heard a lot about how we are advancing toward Next Gen 911, and Maryland is a leader. And it's thanks to the work of the commission and the support of the General Assembly that we're there. But with all of that, we need to bolster our state laws now to protect against these sophisticated attacks that absolutely pose a significant threat to the security and stability of our 911 system. So we need these proper safeguards to protect against new and evolving threats, including denial of service attacks and intrusions by malicious hackers. I'll just say that, we often hear about states, local governments being targeted by these hackers, by these foreign governments. You hear about private companies being hacked. And we often don't hear about public safety agencies that are victims here, but I can guarantee you that it happens. And you just heard about what happened in Baltimore City. These kind of attacks jeopardize sensitive information and they disrupt emergency services. So we need to pass this bill because it will enhance public safety communications in Maryland and protect public safety generally so that these first responders can go out and do what they do every single day, which is save lives. So with that, we'd urge a favorable report on Senate Bill 83.
So thank you very much. All right, next we have Mr. Markey. Are you still here? You're up next.
Thank you, Mr. Chairman, members of the committee. Jack Markey, Director of Emergency Management for Frederick County, member of the Maryland 911 Board, incoming chairman of the 911 Board, and for the last 4 years, a member of the Commission to Advance Next Generation 911. SB 83, I urge your favorable support. Securing 911 networks is not a singular responsibility of any one entity. It requires coordinated action between state and local government, as well as our technology partners in the wireless and wired telecommunications worlds. In order to protect our networks, we must all take concerted action, both at the technical level and unfortunately also at the legislative level, to ensure there are penalties to deter those who may seek to harm 911 and may seek to bring our networks down. And when necessary, laws that can be used to prosecute those individuals involved in those actions. I urge your favorable support for SB 83.
So thank you. And with that, that'll conclude the testimony for Senate Bill 83. For 71. We'll now switch over to the committee for questions.
83. 83
83
was right, Mr. Chairman.
There, you're right. All right. Seeing no questions from the committee, that'll conclude the hearing for Senate Bill 83. Thank you very much, Senator Kagan.
Thank you, colleagues. Stay well. Take care.
All right, excellent. Have a good one. All right, now we'll switch over to Senator Bailey with Senate Bill 68. Senator Bailey, you're up. Good to see you.
Nice to see you. Good afternoon, Chairman Smith, Good afternoon to the other distinguished members of the committee. For the record, Senator Bailey, representing District 29, St. Mary's and Calvert County. Today, I'm introducing Senate Bill 68, which deals with sexual offenses, crimes of violence, and lifetime supervision. This bill resolves an inconsistency in current Maryland law and ensures that offenders who commit sexual abuse of a minor are subject to existing penalties and supervision to decrease the risk of recidivism. Under current law, an offender who commits sexual abuse of a minor in a violation of 3602 of the criminal law article against a minor under the age of 13 is considered to have committed a crime of violence under certain circumstances, while an offender who violates 3602 against a minor under the age of 12 is subject to lifetime supervision. This inconsistency means that a person who commits this crime against a victim who is 12 years old has committed a crime of violence, but is not subject to lifetime supervision. This bill makes these provisions consistent by requiring lifetime supervision for offenders who violate 3602 against a minor under the age of 13. I think we all understand that whether they're 12 or 13, they should have the same exact penalty. The other provisions of this bill address incidences of 3602 where the victim is 13, 14, or 15 years old. These victims deserve the same protections as those who are under the age of 13. This bill specifies that in cases where the victim is between age 13 and 15, the crime of violence statute and lifetime supervision will only apply to the offenders who are 21 years or older. This bill makes no other changes to the circumstances already in law for when a violation of 3602 is considered to be a crime of violence. Senate Bill 68 is narrowly targeted to protect Marylanders from a relatively small but significant number of offenders who have committed these very serious crimes. This bill is prospective and does not apply to any conviction before the bill's effective date. This bill is nearly identical to Senate Bill 268 from last session, which passed out of the Senate 46-0. Senate Bill 68 is designed to protect our most vulnerable citizens from some of the most heinous crimes, specifically felony sexual assaults. I respectfully request a favorable report on Senate Bill 68. Thank you for your consideration, and I now turn it over to my very qualified panel.
Excellent. Thank you very much, Senator Bailey. And we'll now move on to your panel. We'll start off with Ms. Marsh. You are up next. Welcome.
Thank you. Good afternoon, Mr. Chairman and members of the committee. My name is Catherine Marsh. I'm the Special Victims Liaison Attorney with the Charles County State's Attorney's Office, and I'm testifying on behalf of the Maryland State's Attorneys Association in support of this bill. I had a victim who wanted to be here until she learned her testimony would be on YouTube, and I'm sure all of you can understand how difficult that would be for a young victim. And so I will be sharing her case in her stead. This brave young woman came forward when she was 15 about the sexual abuse she'd been suffering at the hands of her stepfather for years. She testified at the trial, and the jury convicted the stepdad of sex abuse of a minor. His DNA had been recovered when she'd undergone a sexual assault forensic exam shortly after the last incident. The jury did not convict, however, on the historic abuse that occurred between the ages of 11 and 14. As one of the jurors said, there wasn't DNA evidence for that. This brave victim was left with a hollow victory, one that told her that the sexual abuse she suffered was not a crime of violence, that she was not entitled to the peace of mind of knowing her abuser would have to serve at least 50% of his sentence before being eligible for parole. And although he is incarcerated now, she knows that next year he's eligible for parole after serving just a quarter of his sentence. 66% of child victims of sexual assault in this country are between the ages of 12 and 17, and we are currently failing them. With regard to the lifetime registration component, this bill merely fixes oversights within the law. In 2017, the General Assembly determined that there is no difference between second-degree rape and second-degree sexual assault, and these crimes should be treated the same. This statute was left out. The legislation before you today will fix this oversight and ensure that there is parity under the law. As this committee knows, this is not the first time this legislation has been before you. I want to thank Senator Bailey, Jamie Sterling, and Annie Kenney for their continued work on this legislation. But most importantly, this committee, the time and attention that you have put into this legislation and the changes that you made last year directly led to the Senate unanimously passing this legislation last year, and I urge a favorable report.
Thank you very much, Ms. Marsh, and we'll now move on to Ms. Feinstein. Debbie, you're up. Good to see you. Welcome.
Nice to see you as well. Good afternoon, Chairman Smith, as well as members of the committee. My name is Debbie Feinstein. I am the Chief of the Special Victims Division for the Montgomery County State's Attorney's Office, and I'm the current chair of the Domestic Violence Subcommittee for the Maryland State's Attorneys Association. This bill is incredibly important to the most vulnerable members of our community, as Senator Bailey mentioned. We're talking about children who've been sexually abused by people in positions of trust. There are a couple of examples that just occurred recently in Montgomery County that really brought the importance of this legislation to a head for me and my community and the individuals that we prosecute. I recently prosecuted a case where a school teacher sexually abused two 14-year-old students. He used his position of trust to gain their trust and to groom them and develop a relationship with them. And he sexually abused them. However, they're both 14. He entered plea of guilty to sexual abuse of a minor, and his sentence will be a quarter of the time if they'd been 12. The sexual abuse that he perpetrated on them is no better than what would happen to a 12-year-old. They were traumatized, victimized in the worst way possible by this person that they were supposed to trust. We had another recent case where a 13-year-old was groomed by a family friend who convinced the child's mother that this child was going to be a model for him, and not sure sort of where all that came from, but it resulted in him, taking care and custody of that child, performing a number of sexual violations on her. Again, he was sentenced on a sexual abuse of a minor count to 7 years. He'll be eligible for parole in 1.75 years, because only a quarter of time, because she was 13 and not under the age of 13. This is a disparity in the law. This is something that, from the state's attorney's perspective, from my perspective, doesn't make sense. That we should be treating children under the age of 13 differently than we should be treating those 13, 14, 15-year-old kids that are victimized in the same way. I thank you for your consideration, and I urge the Senate support of Senate Bill 68, and thank you for your support last year and hope that it continues. Thank you again.
Thank you, Ms. Feinstein. We'll now move on to Ms. Graff. Jessica here, is that? All right, I don't see Ms. Graff here, so we'll move on to Ms. Kenney. You're up. Good to see you.
Okay, can you hear me now? So, hi, I'm Annie Kenney, and I am a single mother to 3 daughters from St. Mary's County. Several years ago, I discovered that my husband was abusing our oldest daughter. He was indicted on felony child sex abuse charges, and he is now a Tier 3 registered sex offender for life. He is not subject to lifetime supervision because the daughter he was convicted of abusing was 15 at the time she disclosed. But it's actually my middle daughter, who was 8 at the time of his arrest, who is not capable of going through the same processes that her older sister went through, that is suffering the most. This is my 4th year working on this bill, and I've told you a little bit about my daughter before and how she started cutting herself and running away at the age of 10, and how at 11 she had her first psychiatric hospital admission. Well, now at 12, she spent 3 weeks of her summer vacation last summer in a psychiatric hospital. 3 weeks. She is so mad at the whole world, and she has panic attacks, and she throws up at school, and she lays on the floor at night crying, saying her body just doesn't feel right and there's nothing we can do to fix it. Her name is Nora, and she is dying a slow, painful death. You're missing the point. You're not focusing on the aftermath of this type of horrific crime. There's been a lot of hypotheticals tossed around, a lot of worrying about whether or not someone would be punished too severely by being subject to lifetime supervision. But let's stay focused on what is true. We are not talking about all child sex crimes. We are talking about sexual abuse of a minor. It is the worst of the worst, and it's time to start believing that someone convicted of that charge deserve to be convicted of that charge. We can't dumb down sentencing requirements worrying about wrongful convictions. The job here isn't to determine whether or not someone deserved to be convicted of first-degree murder. It's to make sure the right punishments, our boundaries are in place once a conviction is made. I just think we need to stop trying to talk ourselves out of this and focus on the fact that once we know someone is capable of this horrific crime, that we need the opportunity to keep boundaries in place going forward. Real quick, I just want to note that my ex-husband has been incarcerated for the past year for allegedly molesting additional children after his original conviction. So he's just pled guilty. And since he was still on probation, the 10 years from my case will be added to his sentence. Thank you for your time.
Thank you very much, Ms. Kennedy. Always good to see you. Thank you for taking the time to, again, share your story and your experience and offer your testimony. All right, we'll now go back to Garth. Is Ms. Garth back in the room? There you are. Welcome.
Good afternoon, Mr. Chairman, Mr. Vice Chair, members of the committee. My name is Jessica Garth, and I'm the Chief of the Special Victims and Family Violence Unit at the State's Attorney's Office for Prince George's County. I'm here to show my strong support for Senate Bill 68 on behalf of State's Attorney Aisha Braveboy, my office, and the MSAA. And I'm here to also urge a favorable report. Like ASA Marsh and ASA Feinstein, one of the most difficult conversations that my attorneys and I have with our victims is that our abusers for our victims who are 15 or 14 years old are going to be eligible for parole after only serving a quarter of the sentence. Often the highest sentencing guidelines for these offenders are about 10 years. So we're talking about eligibility for parole after 2.5 years for somebody who has sexually abused a child. This is just one more injustice that is suffered by these child victims, and it is something that I think and that I would urge this committee to correct. Senate Bill 68 also serves to bring the language of the Lifetime Sexual Offender Supervision Statute in line with other recent legislative changes. And this would just further increase equity between people who are victims of second-degree rape and victims of second-degree sexual assault. These survivors do deserve to be treated equally under the law. And I do believe that reducing the amount of sexual abuse of children and providing equitable treatment to all victims in our communities are goals that we can all share. Thank you for your time today. And I would like to, again, respectfully urge a favorable report on this Senate bill. Thank you.
Thank you, Ms. Garth. We'll now move on to Mr. Smith, Charlie Smith. Here we go. There you go. Oh, let's do one more time. There we go.
All right. Can you hear me now?
We can. Yes.
Okay. Thank you, Chairman, committee members. Charlie Smith, State's Attorney for Frederick County. Prior to being elected to State's Attorney out here, I actually was chair of the Special Victims Unit, what we call the Child Abuse and Sex Offense Unit. So tried a lot of these cases. And really what I view Senate Bill 68 as is really just a housekeeping measure. What you all, in doing by passing this, would really just be closing a loophole, closing an anomaly that's existed in this law that I'm surprised has been brought to everybody's attention prior to this. So, I mean, the thought of this being not a crime of violence when you have a 14-year-old is just really, it's sort of insane, defies logic. So I know you've heard a lot of compelling stories about why to pass this bill with regard to lifetime supervision. Truly, again, I view it as a housekeeping measure. I view it as something that just needs to be done because it should have been done a long time ago. And somehow the fact that we haven't been treating 14 and 15-year-old victims as a crime of violence when they're molested or abused is, again, just mind-boggling. So I would urge you to pass Senate Bill 68 out of committee really as a housekeeping measure. I know I've said that multiple times, but that's how I view it. So thank you all for hearing from me. I'd be more than happy to answer any questions if you have those.
And thank you very much, Mr. Smith. And we'll now head into our final witness for the panel, and that's Ms. Proctor. You're up. Welcome.
Well, thank you. Good afternoon, Mr. Chairman and committee. I am testifying in support of the Senate Bill 68 and asking for a favorable report on behalf of the Maryland State Attorneys Association and Richard Fritz, State Attorney for St. Mary's County. I've been a criminal prosecutor in Charles and St. Mary's for 8 years, primarily focusing on the sexual abuse crimes to minors, to children. Unfortunately, during those 8 years, I've had to have the very difficult and unequitable conversations with parents of minor victims due to the sexual child abuse because of the lack of lifetime supervision and the lack of equal designation for the crime of violence for all ages of the minors. So the recidivism of sexual abuse should be a goal of all, no matter who's advocating for who. As Ms. Kenny has testified to you all today, she's been here before you all in the House, requesting the lifetime supervision. I testified alongside Ms. Kenny 2 years ago in front of the House Committee for the lifetime supervision. At that time, her ex-husband was on probation. Well, in the last 2 years, specifically last year, I prosecuted her ex-husband again for reoffending sexual contact to a 10-year-old girl. He has pled guilty. Sentencing is to be imposed when we get out of this COVID backlog of the evaluations and PSIs due. But he ended up pleading guilty to sexual contact to a 10-year-old girl. So that's the recidivism rate we are at, with what's just one example of a case that you all know very well through Ms. Kenny's repeated testimony before you. In Charles County, as a prosecutor, I recall at least 2 cases in which the sexual offenders were no longer on any type of probation. One of those mothers did testify 2 years before the House Committee as well. The other one submitted written testimony.
Time.
I will close with requesting a favorable report. We cannot let the registry and the public record of criminal history be the only line of defense of recidivism. Thank you.
Thank you very much. And with that, Ms. Proctor, that'll conclude the testimony for Senate Bill 68. We'll now move to the committee members for questions. Seeing none, that'll conclude the hearing for Senate Bill 68. Senator Bailey, thank you very much. And thank you to your panel. We'll look forward to working with you on this. All right, we'll now move on to Senator Kramer. Senator Kramer, good afternoon. Welcome. Senator Kramer with Senate Bill 71. You're up.
Good afternoon, Mr. Chair. Thank you for that. Good to be back with the Judicial Proceedings Committee today. I am here, Mr. Chair, Ben Kramer, to introduce Senate Bill 71. Colleagues, this is a bill that will be familiar to you. The bill would enshrine in state law a civil remedy for the victim of a hate crime. I won't get too in-depth into the bill, as you all are familiar with it, having heard it before, and I think you all can appreciate the value that this legislation brings in addressing the rampant hate crimes that are so pervasive, not just across the country, but here in Maryland. And I think we have an obligation and a responsibility as legislators to respond to that. Hate crimes are unique in that they target the individual because of what they are. It's because they are a Jew. It's because they are a Muslim. It's because they are a Black person. It's because they are a Latino. It's because they are gay. They are targeted to be victims based on what they are. And that has a terribly harmful effect on not only the individual, but the community, both for those who are members of that same class, as well as the broader community that is threatened and concerned about the prevalence of hate crimes. The bill is very succinct. It's very narrow in its drafting. That is a consequence of commentary from this committee on the introduction of a very similar bill in 2019. Based on the concerns of the committee, it is very narrowly tailored this year. It will provide injunctive relief. It will allow the court to award economic and non-economic damages. It affords the court the opportunity to award attorney's fees, and the court can award treble damages. I think that we are in need of passing this bill so that we elevate the issue of hate crimes and our response to those hate crimes. Our constituents, I think, have every expectation that this legislature is going to take action. We are in Maryland in a minority of states that do not have a civil remedy statute on the books. And it is woefully way behind time that we actually did that. I have to believe that the deterrence factor alone is going to have an impact on hate crimes in our state. And I would ask that committee, Mr. Chair, that we move quickly this year to ensure that the bill does not get lost in the shuffle of all the other important legislation that this committee works on. I would ask that it receive a favorable report and it do so very timely so that we move this legislation and we send the signal to our residents, our constituents, we're taking action. And they can also be far more effective to give victims of a hate crime this civil avenue as opposed to criminal prosecution. This is what brought down the Ku Klux Klan. It was the civil action that brought them to their knees. And I think it is long past time that we took this action and provide this opportunity for a victim of a hate crime to be made whole. With that, Mr. Chair, happy to turn it over to the panel.
Thank you very much, Senator Kramer, and thank you for bringing this to us again here. We'll go on to your panel. We'll start out with, I think I saw Meredith here. Is Meredith, Ms. Swizell here? There you are.
I'm here.
Welcome.
Thank you, Mr. Chairman. Always wonderful to be with the Judicial Proceedings Committee. You have heard me testify before on this bill. Just for the record, Meredith Weisel, the Deputy Regional Director for ADL's Washington, D.C. office, and we're here again this year to support Senate Bill 71, the Hate Crime Civil Remedy Bill. Just as a reminder, ADL is one of the leading anti-hate organizations. We're committed to stopping the defamation of the Jewish people, securing justice and fair treatment to all, and of course to dedicating combating anti-Semitism, prejudice, bigotry of all kinds, and defending democratic ideals and promoting civil rights. Now, specifically on this bill, as a reminder, back in 1981, ADL was actually the organization that crafted the first model hate crime law in the country. And with that, today we have about 46, almost 47 states, including the District of Columbia, that have hate crime laws on the books, and 33 states, including the District of Columbia, grant hate crime victims a civil cause of action. This is to pursue statutory claims for the harm that the hate crimes can cause. It's important, I think, when we're having this discussion to remember that behind every hate crime statistic, we know that there's the community, the person, the family, Everybody is dealing with the unimaginable, and hate crimes are very different than others because they really do cause a distinct type of harm that can have a lasting and measurable impact. You're targeting somebody based on their protective, immutable characteristic. And civil remedies in particular, these provisions can really be the powerful tools for hate crime victims. And it's important to remember that the victims can recover for the harm caused by the bias motivation itself. We're not just merely talking about the damages that may flow from an underlying tort. This provides a necessary stopgap in cases where prosecutors, for a variety of reasons, may not be able to prove a bias motivation beyond a reasonable doubt. So with that, we urge the Senate committee to give a favorable report of Senate Bill 71. Thank you.
So thank you very much, Ms. Wazell. We'll now move on to Ms. Miller. Ms. Miller, there you are. There. Excellent.
Good afternoon, Mr. Chairman and members of the committee. I'm Deborah Miller, the Director of Maryland Government and Community Relations for the JCRC of Greater Washington. I'm also here today in support of Senate Bill 71, Hate Crime Civil Remedy. As many of you know, the JCRC is the umbrella group representing over 100 Jewish agencies, synagogues, and schools in the region. And our top priority is to advocate not only for the security of our Jewish community, but for all faith communities. And we work to promote religious freedom and social justice and to combat anti-Semitism and all forms of hatred. So given this mission, we clearly support Senator Kramer's bill. Any and every measure to strengthen the state's current hate crimes laws are critical to fighting against the current rise of extremism and intolerance. And people should be able to practice their religion freely and without fear of becoming the target of a violent act, a hate crime, or a bias incident. Maryland, of course, has strong hate crime laws on the books. However, if you are the victim of a hate crime, you should be able to file a civil lawsuit and seek damages, as been articulated by Ms. Wiesel and Senator Kramer. I'm sure you know this, but I'm going to reiterate it, that Jews only represent 2% of the population, but FBI statistics indicate that they constitute nearly 60% of all anti-religious hate or bias crimes in the country. And in Maryland, as Ms. Wiesel can attest to, according to the ADL's latest report, incidents and threats against the Jewish community showed a dramatic rise, up 135% from the previous year here in Maryland. Again, the very recent terror and anti-Semitic attack at a Texas synagogue is yet another disturbing reminder of why it's imperative to strengthen our hate crimes laws and offer civil remedies to targeted victims. So for these reasons, we too ask for a favorable report on Senate Bill 71. Thank you, Mr. Chairman and the committee.
Thank you very much, Ms. Miller. Good to see you. We will now move on to Mr. Peterson. Matt, we are.
Hi, good afternoon. Thank you, Chair Smith and Vice Chair Waldstreicher, for having me. My name is Matt Peterson, here on behalf of the Baltimore Jewish Council in support of SB 71. We heard about what this bill will do, but I just want to share why in 2022 it is so necessary that we make this small but significant change to the law. As with my colleagues at the ADL and the JCRC of Greater Washington, we at the Baltimore Jewish Council work every day to address the unfortunate rise in anti-Semitism and hate crimes, which has been rising here in Maryland and across the United States. And like we just heard, this past Saturday, an armed terrorist entered a synagogue in Coleyville, Texas, where he was let in just because the congregants thought he needed a place to get out of the cold. But he proceeded to take them hostage and hold them at gunpoint for 11 hours. And while thankfully none of the hostages were physically injured, we do know that an incident like this will live with those victims for the rest of their lives. And the mental damage can be just as painful as even a severe injury. So a law like this would help victims of a violent hate crime like that, or any incident of hate or bias, get the remedies that they need and have the compensation. And finally, they'll be able to seek full justice for the the unfortunate crimes that they've been a victim of. So with that in mind, we do ask for a favorable report on SB 71, and I thank you for your time and I'm happy to address any questions.
Thank you very much, Mr. Peterson. Good to see you. We'll now move on to Mr. Yost. You are.
Good afternoon, Chairman Smith, Vice Chair Waldstreicher. I'm here today. My name is Tom Yost. I'm here today on behalf of the Maryland Association for Justice. I would urge you to report favorably on Senate Bill 71. This is a very timely bill, not just in Maryland, but in our neighboring states in Virginia and actually throughout the country. We're seeing a lot of people express hateful opinions by their actions. They're in the news. People are being killed. People are being endangered. People are being harmed. Property is being destroyed. That's against the law in Maryland because of the hate crime laws that we have under the Criminal Code 10, section subtitle 3. But victims can't always do very much about it. Once they report a crime, maybe it gets prosecuted, maybe it doesn't. If it does get prosecuted in the days of COVID, it could take a couple years for a matter like this to get to trial. This bill provides an immediate source of access to the courts for victims of hate crime. And let's start with who these victims are. The victims are identified within the criminal code section. They're people who are being harmed, threatened, prevented from practicing their religion, or having their property burned down or destroyed, or intimidated based upon race, color, religious belief, sexual orientation, gender identity now, disability, natural origin, or even homelessness. People who are the victims, your constituents who are the victims of hate crimes. Now, one of the important tools that this statute provides is a civil injunction. If something is ongoing and you file a criminal action against it, there's not a whole lot the court's going to do. But if you have a civil remedy and the ability to bring an injunction, the ability to go for an injunction, you can stop the action before it gets worse. It provides for a monetary judgment, for property damage, for injury, and for emotional harm that's related to the harassment and the hate crime, but not the loss of your property. These are unique harms suffered by a very vulnerable, limited group of vulnerable people in our society. The regular tort system does not provide an adequate remedy. And this can potentially deter people that would fund these operations because there is a simple remedy and that money will go to. I urge you to report favorably on Senate Bill 71. Thank you.
Excellent. Thank you very much, Mr. Yost. And finally, rounding out the panel is Mr. Greenberg. You're up.
Thank you, Chairman Smith, Vice Chair Waldstreicher, and Senators. On behalf of the Maryland Association for Justice, as Tom said, we support Senator Kramer's courageous and logical bill. It's really about basic human values and needs. The ability of every American to pursue health and happiness, earn a living, be safe in their communities and serve their country, take care of their loved ones without being the victims of hate crimes. As you know, Maryland Association for Justice envisions a fair and impartial legal system that protects the rights and safety of all people. And this bill provides that those people who are the victims of hate crime be able to seek redress against not only people, but organizations and hold them financially accountable. It's time that Maryland falls into the majority of states that recognize that those who spew hate speech must be civilly sanctioned for their acts. We do request a favorable reporting for Senate Bill 71. Thank you, Senator Kramer.
Excellent. Thank you very much. And with that, that'll conclude the testimony for Senate Bill 71. We'll now turn to the committee for questions. And we have first one with Senator Lee, and then we'll head off to Senator West, and then Senator Castley. So Senator Lee, you're up.
Yeah, thank you, Mr. Chairman. And thank you, Senator Kramer, for bringing this very important bill. Can you hear me?
We can.
Okay. I think this is a great bill. It's Jewish community has experienced a huge surge in hate crimes, but the Asian American Pacific Islander community has also experienced, at least from last year, 155% surge in hate crimes against that community. So I see this as a very good bill. It's not only a great deterrent, but I think it makes it'll make the victims whole too, as Thomas Jost indicated and Mr. Greenberg. But I also like to thank Meredith Weissel for partnering with our Asian American Pacific Islander community on fighting hate crimes, partnering the two communities together to fight this together. My question is, with respect to a civil action, which I think is good, it's long needed. Do you have to show the elements of the hate crimes, the same standard that we passed maybe in the bill in 2020 dealing with, substantially motivated by hate? Do we have to use that standard in order to prevail in this civil case?
Quite frankly, Senator Lee, as the bill is drafted, it simply states that a person who is the victim that would constitute a violation of this subtitle. So that's the basis. And my response to you is that if it is a violation of one of the enumerated hate crimes in 10301 of the criminal law article, then the individual has the opportunity to pursue civil litigation.
Just wanted to know what the standard was. Is it like substantially motivated by hate, or just all because, remember in 2020, we passed Senator Benson's bill?
I think that would be a matter.
Crime, because it was almost impossible to prove a hate crime in Maryland until we amended that standard. So now we're able to hopefully bring a civil case against individuals or organizations that are committing these atrocious, egregious hate crimes. So would the standard be substantially motivated? Or maybe Larry or Thomas can answer that question. Go ahead.
Go ahead, Larry. You're unmuted first, and then we'll go to Tom if you want to chime in.
Thanks, Chair. So the answer is, and we can work with Senator Kramer to ensure the language is proper, but the civil standard versus the criminal standard is different. And I know, Senator Lee, you know that. At the end of the day, you are proving the breach of, I believe it's 10301 and the statute in whole. So the actual language, as long as it's simplistic and everyone knows exactly what it says is what it means, we will work with Senator Kramer to ensure that legally it's appropriate and it's not easier. Tom, I saw you raising your hand before.
I think this bill encompasses the criminal code, and under section 10304, the preamble to that section says that the actions have to be motivated either in whole or in substantial part by another person's or group's race, color, religious beliefs, sexual orientation, and it goes on to describe the people. So the criminal code for a criminal prosecution would require someone to prove beyond a reasonable doubt that the action was motivated either in whole or in substantial part by this desire to hurt someone because of their hate. But in the civil arena, for a civil remedy, you wouldn't have to prove that beyond a reasonable doubt. You would just have to show it's 51%, more likely so than not. So there is a lower remedy to receive civil damages from a hate group or a person committing a hate crime under this bill than it would be to convict them and potentially put them in jail.
Okay, thank you for that clarification. That's what I really wanted. I wanted to know if it's the same, the criminal standard be the same as the civil, but thank goodness the civil is not as high. Thank you, Thomas, for answering that, and Larry too.
All right, thank you very much, Senator Lee. Ms. Wiesel, I know did you want to chime in, or are we good to go? You're good? Okay, excellent. All right, we'll now move on to Senator West, and then we'll go to Senator Castley. Senator West.
Thank you, Mr. Chair. And I think that Tom Yost just answered my question. So thanks, Tom.
Love when that happens. All right, we'll go on to Senator Castley.
Thank you. Just a technical question. Section D says that it's on the treble damages, and that's on both economic and non-economic damages. Is that the usual, that treble is on both economic and non-economic damage when it's awarded? Tom Yost has his hand up. You and Mr. Yost.
Yeah, Senator Castley, thank you for your question. You know, there are very few statutes that actually permit treble damages. So one that comes to mind is the Consumer Protection Act that only awards this in like heinous conduct where you're defrauding people for profit, and it's a higher standard. Like here, where there has to be a standard proving a hate crime. But yes, the treble damages can be awarded. They don't have to be awarded. It's discretionary by the judge, but they can be awarded on both economic and non-economic damages. That's correct.
And that's how it's read. I'm sorry. That's how it is in the Consumer Protection Statute currently, both.
I think the Consumer Protection Action primarily, I know that it deals with both. Yes, that's how it is, I think, in both, because the Consumer Protection Statute, although talking about consumer fraud, is also used in personal injury matters for violation of that. So yes, I've not seen judges award treble damages in issues involving personal injury in over 3 decades that I've practiced, but it is used more commonly for economic damages. Correct, as a deterrent for this conduct.
Right. I'm thinking normally if you think of non-economic damages, you seek an award of 3 times economic, maybe 4 as a multiplier on the economic damages. So if the jury awards non-economic as a multiplier of 3 on economic, and then you multiply that by 3 on both of them, we're getting a lot of multipliers in there. So, okay.
We have to trust our judiciary. I think it's up to the judge's discretion with the individual case. And once they make the non-economic award,
well, this could be a jury
probably
case.
Covers it all.
But this can be jury, right? Or is this not a jury trial?
I think you could have a jury trial, but I don't know that jurors would be able to award treble damages.
Well, oh, I see. This is awarded by the court. So was the intent that the jury would award damages, and then the court would then come back and can award the punitives? Is how this reads then?
I wouldn't call it punitives, but the way my experience has been, it's up to the judge. It's up to a judge to award treble damages. Usually, I've never seen that.
So that it's intended to read that way. We would have the jury would come in and award economic and non-economic, then the judge could then throw on up to treble of those 2 combined. I have to
read it more critically.
The bill does specify. This bill specifies the court, so it would the judge, not the jury, making that determination.
Okay, thank you. Appreciate it.
Thank you very much, Senator Castley. Senator West, your hand is still up. Are you still good to go? You're good? Okay, great. We'll go to Vice Chair Walstriker.
Thank you, Mr. Chairman. And I just want to kind of build upon what Senator Lee said earlier. The level of hate in our community throughout the state, throughout this nation is just terrible and unacceptable. And the same day that the British terrorists took Jews hostage in Texas, an Asian American was pushed onto the tracks and murdered in New York City. And we see these terrible acts all over the place. And what is disturbing to me, and I know disturbing to many on this call, is the extent to which this somehow has become normalized and acceptable in our society, not only in violent ways, but also in more subtle, more insidious ways. And so I just want to thank the sponsor for bringing this bill and to say, adding this tool in our toolbox, a civil remedy, in addition to our criminal remedies, provides a statement from our committee and from this body that we're not going to accept this level of hate against any minorities, racial or religious. So thank you again to the sponsor, and thank you, Mr. Chairman.
And if I may, thank you for your comments, Mr. Vice Chair. You are absolutely correct. And your message just now hopefully will resonate with the committee and our colleagues throughout the legislature. And it is a demonstration to the public that we are taking this matter very seriously and providing this additional tool that we really need to have, and elevating the issue so that we're hopefully also creating a deterrent in what we're doing. So thank you for your comments, sir.
Excellent. Thank you very much. Looking around the room for additional questions. Seeing no further questions, thank you, Senator Kramer. Thank you very much, and thank you to your panelists. With that, that'll conclude the hearing for Senate Bill 71. We'll now move on to Senate Bill 22. Is Senator Lamb in the room? Senator Lamb.
Yes, I
Hey.
am. So let me try to unmute the other, my EHE committee that I'm attending to now. So just give me 1 second.
Of course. We're all multitasking these days.
All right. So appreciate the opportunity to speak with all of you. So this is Senate Bill 22. And so good afternoon. Thank you, Chairman Smith, as well as Vice Chair Waldstreicher, members of the committee, for allowing me to testify before you on support of Senate Bill 22, as you know, for the record, in Clarence Land Center, District 12. So you may recognize the provisions of this bill from 2020. This was because 2 years ago, Delegate Moon and I proposed a repeal of both the common law crime of sodomy and the provisions called, quote, unnatural and perverted sexual practice that's currently in statute. Although the House passed HB 81 by a vote of 133 to 5, repealing both provisions, but amendments that were made in the Senate during the 2020 session meant that it went to the Senate floor with only repeal specific to sodomy. At that time, you may recall that there was still an active discussion occurring within the Senate regarding the repeal of Section 3-322, which is the unnatural and perverted sexual practice parts of the statute, when the legislature was forced at that time to adjourn early in 2020 due to the pandemic. So I'm returning with this bill this year to complete the unfinished business from 2020. So the problem is that the provisions in the section prohibit some sexual activities that are consensual, private, not commercial in nature, and better addressed by more updated parts of the code, including those pertaining to animal abuse. This section also makes oral sex and sexual abuse of animals a criminal offense punishable by up to 10 years in prison. Overall, the sexual offenses in this section have been ruled by the Supreme Court and the Maryland judiciary to be unconstitutional or otherwise unenforceable, except in cases that involve a lack of consent or force, regardless of the gender of those involved. The very nature and title of the section of the statute, unnatural and perverted sexual practice, represents an outdated and discriminatory sexual offense perspective that, as I will point out, is no longer necessary. The law is particularly offensive to the LGBTQ community, at least in part because it has been historically applied in a discriminatory way. Changes for the outdated sexual offense have predominantly and unfairly been applied to LGBTQ individuals, particularly to gay men. A case here in Maryland just last year had local law enforcement issue criminal charges against men engaged in consensual sexual activities. Some of these charges based on this section of the statute that even a local prosecutor appeared to decline to pursue. So passing SB 22 would reduce stigmatization of the LGBTQ community by striking an unnecessary and offensive statute without creating loopholes for other sexual offenses. Cases that have been charged using this provision can be addressed using other sections of the existing code. There are other sections that contain updated language and penalties that are more consistent with current judicial reasoning and decisions. So as a result, I believe the section is duplicative as well as outdated and discriminatory. However, since this provision has been narrowly applied in recent years, mostly in cases that were non-consensual or involving force, SB 22 limits expungement and removal from the sex offender registry. This bill also ensures that individuals previously convicted using these repealed provisions, that is, those who used force, abused minors, and committed sexual crimes against animals, will not be permitted to expunge these convictions or to remove themselves from the sex offender registry in these cases. As I mentioned, Section 3-322 of the statute also contains some outdated prohibitions pertaining to sexual abuse of animals. These prohibitions were actually updated and expanded in the aggravated cruelty to animals section of the code in 2019. This is Section 10-606. But the duplicative and outdated provisions that are in Section 3-322 that we're discussing now were unfortunately not removed at that time. So repealing the section does not reduce or interfere with any of the protections for animals that already exist under Section 10-606. Numerous other provisions in criminal statute exist that are not offensive to the LGBTQ Marylanders, and also capture a wide spectrum of sexual offenders that make this section obsolete. Duplicative and obsolete language such as this, I believe, should be removed to maintain the integrity, effectiveness, and proper enforcement of our laws. And so that concludes my testimony on SB 22. I'd like to particularly thank Senator Waldstreicher for agreeing to co-sponsor this bill. I apologize we didn't get your name on this before as a co-sponsor before it was pre-filed because of the new process that's in place. So it's my understanding that we can have your name added if the committee votes in favor of the bill during the voting session. And then I think we have 3 panelists that are coming up, including CP Hoffman from Free State Justice, Terry Williams from the Attorney General's office, as well as Leslie Hoffman from the from MCASA. So I'd like to thank the committee for your consideration and urge you to issue a favorable report on SB 22. Back to you, Mr. Chair.
Excellent. Thank you very much, Senator Lamb. Next, we'll have CP Hoffman, and then we'll have Ms. Jordan. I think Lisa's there. She is. She's up. So we'll go CP Hoffman, then Lisa up next.
Hi, thank you, Chair, Vice Chair, members of the committee. I'm CP Hoffman. I've spoken before, many of you before. I am the Policy Director at Free State Justice, which is Maryland's LGBTQ plus advocacy organization. I'm here to talk about how Section 3-322 is really a vestige of another era when institutionalized homophobia and policing of what went on within the bedroom, including the marital bedroom, was seen as like a legitimate legislative purpose in Maryland. And I argue that we have moved well past that. Over the past 5 decades, we've seen a lot of advances for LGBTQ Marylanders, but still Section 3-322 remains on the books. And as we saw in the Harford County cases that Senator Lamb mentioned, it's still used occasionally. And even if prosecutors ultimately decide not to bring charges, the fact that someone has been arrested is still on their record, and they still will have to go through, the burdensome process of getting those records expunged and things. And it's really like unfair that anyone would be expected to do that. Last week, I met with a group of LGBTQ seniors as part of a program with Chase Brexton. And when we talked about these arrests and this law, they all expressed so much shock because they were like, how is it that we're still fighting this in 2022? We fought this in the 70s and 80s. Didn't we deal with this? And I had to say, sadly, we're still dealing with it. And I would really argue that it's time to take this off of our books. Finally, if you look at the language of Section 3-322, so much of it is focused on oral sex. And if we look at surveys of Americans, over 85% of adults in the United States have had oral sex, and over 73% of people 60 to 69 report having had oral sex. So I don't think that we should consider that something that's unnatural or perverted, something that a vast majority of people, acknowledge to someone asking them on, in a survey if they've done. Thank you. I encourage a favorable report on SB 22.
And thank you very much, CP. We'll now move on to Ms. Jordan. There we go. Gotcha.
There we go. I
Excellent.
apologize. It said that you were not allowing me to unmute myself, but I don't take that personally. I'm Lisa Jordan. I'm with the Maryland Coalition Against Sexual Assault. We're here in strong support of Senate Bill 22. As many of you know, the Maryland Coalition Against Sexual Assault is the coalition of all of the rape crisis centers across the state of Maryland, and we represent survivors across the state. I know that Ms. Williams and I have coordinated on our testimony. I'm going to address 3 brief points. First, let me address the issue of children. Last year, there were concerns that were raised, or in 2020, about whether there would be unintended consequences if we repealed this law, that somehow child abuse would not be fully addressed. This year, the bill takes care of that by making it extremely clear that any sexual conduct that is a crime is still included in Maryland's definition of child abuse. So I don't think that was necessary. However, this should fully alleviate those concerns. The second issue to raise is the issue of animals. The law that is currently on the books addresses the issue of bestiality. And of course, this is something that we do want to address. But this WISE committee has already addressed it. So you have already amended the cruelty to animals statute, and you moved the provisions regarding having sex with animals to that statute. So that is fully addressed. It does not need to be here in 3-322. And finally, regarding the issue of force, there was a time that this provision was occasionally used in cases where we could not prove physical resistance. But again, this very WISE committee and the General Assembly, you have said clearly by statute that physical resistance is not required to prove that. Now, we're not an affirmative consent state, so you still have to say no. Right? But you no longer need this law to address those cases. And so for those reasons, MCASA urges a favorable report on Senate Bill 22.
Well, thank you very much, Ms. Jordan. And now we'll move on to Ms. Williams. Good to see you. I'll unmute you. It wasn't on purpose. There you go.
Thank you. Good to see you. Good afternoon, Chair Smith and members of the committee. My name is Carrie Williams, and I'm here on behalf of the Maryland Office of the Attorney General. The Attorney General urges this committee to issue a favorable report on Senate Bill 22. The statute prohibiting unnatural and perverted sexual practices is a relic from a time when Maryland criminalized certain sexual acts between consenting adults. It's unconstitutional and unenforceable as written. Repealing the statute will not create a gap in Maryland law. All of the non-consensual and commercial sexual acts that can be prosecuted as unnatural and perverted sexual practices are criminalized elsewhere in the Maryland Code, as I detail in my written testimony to the committee, and I'm happy to answer questions about that here today. Repealing the statute will not result in the legalization of any sexual assaults. The bill also ensures that persons convicted of unnatural and perverted practices prior to the repeal will not be able to expunge their convictions, and that anyone ordered to register as a sex offender based on an unnatural and perverted sexual practice conviction will continue to have to do so after the repeal. The statute prohibiting unnatural and perverted sexual practices serves no legitimate prosecutorial purpose. To that end, it's my understanding that the Maryland State Attorneys Association also supports the repeal of the statute as in favor of Senate Bill 22. The statute is a vestige from a discriminatory past and must be repealed. The Attorney General urges a favorable report on Senate Bill 22. Thank you.
Thank you very much, Ms. Williams. We'll now move on to Sasha. Sasha here? Sandy, do you see?
Her in the waiting room.
Okay. Can we bring her in?
No, I'm saying I don't see her in the waiting room.
Got it. Okay, excellent. So then that will round out the panel. We'll now move on to questions from the committee. I'll start off with Senator Huff, then Senator West, then we'll round it off with Vice Chair Waldstreicher. Senator Huff, you're up.
Yeah, first off, I guess to the Attorney General's office, I don't see testimony from the state's attorneys on this. It was indicated that they support it. I don't see any testimony from the state's attorneys that they're in support of this.
Let me ask, you want to unmute, here you go.
There we go. Yes, they didn't, I attended their legislative committee hearing yesterday. They did not, they just met yesterday, so it was past the deadline because of the Martin Luther King Jr. holiday. But I spoke with Steve Kroll and he authorized me to say today that they are in support of Senate Bill 22.
All right. So the case in Hartford County, was that was charged, was that actually prosecuted under the unnatural and perverted statute?
Would you like to direct your question toward?
I guess whoever can answer that, maybe Lisa or Carrie, whoever was familiar with that one. That was referenced. It was referenced that this is in front of us because of the Hartford County case. And I'm curious if that Hartford County case was actually prosecuted under this statute.
So I didn't reference that in my testimony. I believe it was not prosecuted. I believe the charges were dropped.
The sponsor referenced it. So I guess that was my question. If that's the basis of why we're here, I guess my question is it sounds like that it was not prosecuted then under that statute.
It was not
prosecuted under the statute, but there were charges brought, and because of the fact that the charges were brought, even though there's the decision not to prosecute by the prosecutor, it's still on those individuals' records, and they will still be forced to go through the expungement process to have it removed, which we believe is burdensome and inappropriate in this situation.
Yeah, that's correct. And there were some individuals who were charged by the Hartford County Sheriff's Department with this, and those individuals were jailed for a period of time, probably 6 or 12 hours overnight, because of these charges. And so they, experienced that, I think, unduly necessarily because of this.
Okay, well, I do think it's important to note, though, that no one has been prosecuted. They were not prosecuted under this. So, and I have not pulled the record of the recent prosecutions. The reason the committee made the decision to do what it did on this last time, it was actually my amendment. And just so the record's clear, consenting adults haven't been able to be charged on this, I think, since 2004, when the Supreme Court ruled that you can't charge consenting adults under sodomy. So that's never been at issue, at least in what we have been debating. But nonetheless, the committee decided to remove sodomy so that therefore there wouldn't be any question. And, but it was not being charged. It's being charged, as we were talking about, forget sodomy, it's unnatural perverted practices. That's all that remains. It was noted that, yes, there's another section for animals, but the concern that I had at the time, I'll give you, in 2018, unnatural perverted practices was charged 9 different times. And almost every single one of those cases were people that molested or abused sexually children. And so my concern is, if we remove 3-22, which carries a 10-year misdemeanor for sexually abusing children, I view that as an enhancement, and I don't like to remove anything I see as an enhancement for people that molest or abuse children. So if we pass this bill as 3-22 and the 10-year misdemeanor now gone as a penalty for this unnatural and perverted practices.
All right, we're going to hand it over to Ms. Williams.
Thank you. Thank you for that question, Senator Hoff. It's actually, my understanding is that unnatural and perverted practices is almost exclusively charged as a lesser included to the child sex offense. So it's really not a sentencing enhancement. As a matter of law, it would merge into whatever other conviction for this child sexual offense is convicted by the defendant. So there wouldn't be an extra 10 years opportunity on top of that to sentence those defendants.
All right, but so the additional charge, if we pass this legislation, there's 6 people. Now my information's out of date. This is from 2020. There's 6 individuals who are sitting in the Department of Corrections right now and the majority of them molested children, and they have this charge sitting on them. So if we pass this legislation, this charge will not be available for child molesters. Is that correct?
Yes, but it's my understanding that I don't know, but it would be my suspicion that all of those 6 people sitting in the Department of Corrections were also convicted of other things. And so they're not serving time for unnatural and perverted sexual practices.
They were, but just as a theory of practice, I don't like to remove, and that's why the committee didn't pass this originally and left it in, because this is a charge that state's attorneys are using on people molesting children. And generally speaking, the state's attorneys and folks like that come in and they want us to add additional charges, additional time. And I just have a big discomfort level. You cannot charge this against consenting adults.
That's exactly right. It's unconstitutional as written.
You
and so
cannot
all
charge
of
this. So this is a charge. If we pass this is a charge we're taking off the books for people that are molesting children.
Senator Huff, I would urge you to speak to the Maryland States Attorneys Association.
I did. I showed them the folders last year, and they agreed to my very amendment that the posture this bill is in. They agreed to after I showed them about 20 different charges that they had done across the state, and I will share those with you as well, because I don't understand this, because in 2018, now granted that we dealt with this before, but there were 9 charges alone that year of this. I got a stack like this thick. I showed everyone that this is being charged against child molesters. And that's why we didn't remove unnatural and perverted practices.
Well, again, I would urge you to speak with the Maryland States Attorneys Association again this year.
I will.
Because they're in support of the repeal.
Well, I'm surprised, because I sat there with them last year and I showed them this. And I just, speaking for me, I am 100% that should not be charging consenting adults. That's why I agreed to remove sodomy, because I didn't want that vestige there. I agree with that. Nobody is saying that, but if I am very uncomfortable with removing any charge of any criminal penalty for somebody that molests a child. Thank you.
Something for the state's attorneys to entertain is whether it's used to plead down to that. And do you have to register? Do you have to register on the sex offender registry when you're for unnatural, perverted sex acts? That's something I'd like the state's attorneys to address, I guess, when we get into it. But let's go. So Senator Huff, you done? All right, we'll go to Senator West, and we'll go to Vice Chair Waldstreicher.
Thank you, Mr. Chair. So I'm looking at the bill, and repeatedly the term unnatural or perverted sexual practices is replaced. Not just eliminated, but replaced with a new term that is any other sexual conduct that's a crime. I guess let me address this to Lisa Jordan. Lisa, I'm going through the index of the Maryland Code under sexual crimes, and I find, for example, indecent exposure. So if that is viewed as a sexual conduct that's a crime, then we are defining sexual molestation or exploitation as including indecent exposure, which sounds to me inapt. Isn't there a better term we could come up with? If we need any term at all, why don't we just take out the term unnatural or perverted sexual practices? But if we want to substitute it with another term, the term any other sexual conduct that's a crime seems to me to be over-inclusive. Wouldn't you agree?
Good afternoon, Senator. It's always lovely to see you. Sexual abuse is a term that only talks about minors. And so I would respectfully say that if you do have indecent exposure to a minor, and indecent exposure is a common law crime, it requires intent. So this is not something that's, a casual displaying of genitalia, but something that's intentional, that it does actually fall under sexual abuse, and that this could be very harmful to a child. So I do think that that's appropriate. As to the term sexual conduct, I think that we're always struggling in Maryland. We have sexual contact is defined, sexual act is defined, rape is defined. And so we kind of need to find another term. And this was specifically to address Senator Huff's concern that we not somehow reduce the ability to charge sexual abuse. I agree with you completely. We could eliminate, bracket out unnatural or perverted sexual practices. And I think that that would be appropriate. I would respectfully disagree with Senator Huff about needing to have this additional unnatural and perverted sexual act charge in child abuse cases because of exactly what my colleague Ms. Williams is saying. It merges into these other crimes. So it's not like someone is getting convicted of this plus unnatural and perverted. They might be getting convicted, but then when they're sentenced, it merges in. So there's really no benefit to having that there. And there's a great deal of insult because of the discriminatory history of this statute. And really, I would much prefer that prosecutors charge 3602, which is sexual abuse of a minor, which has a much stronger penalty than be charging this misdemeanor. I don't even want to give them that option in cases involving kids. Let's force their hand into that stronger crime. And I suspect that Senator Huff would also want that stronger crime. So we're really going after sex offenders.
All right, well, let me come back to my original question. So in section 3801, the definition of sexual molestation or exploitation, if we do substitute this language, it's going to read sexual molestation or exploitation includes any other sexual conduct that's a crime. Can you think of any other sexual conduct that's a crime which would not logically fit into the category of sexual molestation or exploitation?
I think if you look at 3709, you have a longer list of sex crimes that do not include force. They include things like a sexual act that creates emotional distress. It was a broadening that the General Assembly enacted, I want to say 3 or so years ago, and that could fall outside of sexual offense, rape, incest, the other enumerated offenses that are listed there. So I would say yes, there are some other crimes that could escape the definitions in 1 through 4 there.
Okay, well, we'll have to work on this, but in the meantime, you might think of whether or not you can come up with another, if we need a term at all to replace unnatural or perverted sexual practices. If we need it, come up with a term that seems to make sense and would not be over-inclusive.
Yes, I would be happy to do that. Thank you. Thank you, Senator.
Thanks.
Thank you, Senator Wetzel. We'll move on to Vice Chair Waldsberger.
Thank you, Mr. Chairman. My question is for Ms. Jordan, but let me preface it with this. I couldn't disagree with the senator from Frederick more. That argument may have been tenable last year. It is not tenable this year, not after what happened in Harford County. And the case has been raised, but I just want to slow it down and talk about exactly what happened in that case and how much of a stain it is on really the history of our state and our treatment of our gay and lesbian neighbors and friends. People were having consensual sex and the police raided the place where that was happening. Now, should it have been happening there? No. But what it was consensual sex between two individuals, two adults. And in the middle of that, they were arrested, they were cuffed, they were booked, they were thrown in jail. And so the minimization that, oh, well, the charges were later dropped, doesn't change the trauma that happened to them and doesn't change the stain that it leaves on the history of this state and what it says about our treatment of our LGBTQ friends and neighbors. And so I just want to thank CP Hoffman and Jeremy LeMaster and the sponsor of the bill for bringing this forward, because what happened in Harford County is unacceptable. And more importantly for this committee, we were told last year that consenting adults are not charged under this. And then just a few months after we adjourned, the exact opposite happened. And so we have to pass this bill because it's the right thing to do. But we also have to pass this bill as a message that if you say something to this committee, we have to rely on your word. And when you betray that word, there are consequences for doing so. And so I just want to put that out there for this committee and turn it over to Ms. Jordan, because I know you have some specifics on this case that you wanted to talk about in some other cases where this was charged, even if it wasn't prosecuted, against consenting adults.
Thank you, Vice Chair Waldstreicher. I very much appreciate that. And I think one of the reasons this bill is so important to the Maryland Coalition Against Sexual Assault is that it's very important that sexual assault in our law is sexual assault. not consensual activity and not something that can be misused in this way. The information I have is actually about other cases. I did have the numbers that were requested before in terms of in district court in fiscal year 2021, there were 157 charges under 322, only one conviction in district court. And then again, in fiscal year 2021 in circuit court, 103 charges and 5 convictions. I suspect that they are, as Senator Huff was positing, cases that may have been involving children that then merged. So I think that the information that we don't have is whether that conviction in those 6 cases really did anything in terms of sentencing. And I wish I felt confident in saying, oh, that must be what happened. But honestly, after the Harford County cases, it does cause me concern. And I wonder if any of those cases do involve consenting adults, and any of those charges, certainly if they were against consenting adults. And I again urge the committee to repeal this very archaic law.
Thank you very much, Ms. Jordan. We'll now go to Senator Lee, then back to Senator Huff. So Senator Lee, you're up.
Okay, yeah, this not necessarily to the this Senator Lamb's bill, because I think Senator Lamb's bill is a good bill, but to Senator West's question. If you recall, this may answer your question, Senator West, with regard to your question. If you recall, in I think it was 2019, we passed a law dealing with the, I think it was HB 641, dealing with sexual conduct with an animal. Do you remember that one? So you might want to look at that. I think we've already covered the issue that you brought up. So you don't do it right now, but and then we can talk about it if you want. So I think that addresses your issue. That's all I have to say, Mr. Chairman.
All right, thank you, Senator Lee. We'll now go back to Senator Huff.
And just to be clear, I mean, nobody's arguing about consenting adults, but I'm just halfway through 18. I went through every one in 19, and there's one in 18, other than a guy who did a 4th-degree sex offense. I can't tell if it's a minor. Every single one of these cases so far, I've gone through half of them. These are all on minors. So I would like someone to show me not where a police officer, stupidly charge something. Let's face it, police officers will overcharge to do things. The prosecutor has discretion to decide what to go forward with or not. The prosecutor didn't go forward with this. I would like for someone to share with me where this was charged against consenting adults, because what I've got a stack here of charges against children who were molested that this charge was used on.
For the CP, go ahead.
Thank you. So as several of my fellow testifiers have mentioned, the law has been significantly changed over the last few years. So I don't think that looking at things from 2018 really will tell us anything about the situation now. Also, I really do think it's important that we look at the way that Section 3-322 is actually written. And if you look at it, the statute is almost entirely unconstitutional in all ways. The only reason that it can still be applied in any way is that almost everything has been written out of it by the Maryland Court of Appeals and by other courts. And so today I'm asking you in this committee to look at this outdated statute that is plainly on its face unconstitutional and repeal it. And if there's a need for something else to fill in a gap that's left behind, then do something else to fill in that gap, because this statute as it's written is clearly wrong.
All right, excellent. Thank you very much, CP. All right, so seeing no further questions, that will conclude the testimony and the hearing for Senate Bill 22. Thank you to the panelists. Thank you, Senator Lamb. We'll now move on to Senator Carter with Senate Bill 151. Senator Carter, are you up and ready? There we go. There you are.
Thank you, Mr. Chair. Good afternoon, committee. It's always a pleasure to see you. And even though it will be every day for the next 85 or so days. I'm bringing this bill, Mr. Chair and members of the committee. It's the second time. Unfortunately, this committee did not see fit to bring it to a vote last year. And while the House did pass it overwhelmingly, it's a bill that seeks to address an ugly behavior that's recently been highlighted by national events. Often on social media, we know it as the Karen behavior, or in some places, a law has actually passed called the Karen Act. It doesn't actually stand for the name Karen. It stands for the behavior that someone exhibits when they falsely make a report or call the police on someone based on their own personal biases, their own racism or homophobia or Islamophobia or whatever phobia or personal bias they have. You might ask the question, as I know many of you will, and I've done it on other bills at times, is this currently something that we've already covered under existing law? We already have a prohibition of making a false report. My answer to you is that no, it's not covered under current law, because even though there's a penalty for making a false report, that doesn't address the actual willful animus that someone might use when specifically making a false report on someone because of their own bias and prejudice against that person. This seeks to address the intent, the discriminatory intent of the act. And so what it does is it adds to the hate crimes, the list of hate crimes, making a false report to a law enforcement officer based in whole or material part on a person's race, color, religious belief, sexual orientation, gender, disability, national origin, or homeless status. Recently, I'd say that the most widespread notable incident that happened was Christian Cooper, a Black man who was in the park in Central Park bird watching when Amy Cooper, a person of the same name but no relation, a white woman, called the police on him after he requested that she adhere to park rules and leash her dog. Indignant, Amy Cooper threatened Christian Cooper, warning as she dialed 911, "I'm going to tell them, the police, that there's an African-American man threatening my life." She then made good on her threat, which the public learned was rooted in falsehood because Christian reported the encounter on his cell phone. Fortunately, the prevalence of cell phones, unfortunately, the prevalence of cell phones is not always there. And so you may ask the question, is this really a thing here in Maryland? Well, there are a number of documented incidences that we know about in Maryland. Last year, Willie Flowers, and I'm not sure if he's here to testify today, but he's the president of the Howard County NAACP, testified about his own incident that occurred in Howard County. And then also in my written testimony, I highlight another incident that also was reported in the public arena, which was the example of Barry and Barbara Wallace, who went into a Costco in Arundel Mills when a manager, a white man, called 911 because he felt they fit the bill of ink cartridge thieves. "I need police immediately," the Costco wholesale caller reported. "I have a robbery in progress." The caller described them to the police as an African-American couple. The Wallaces were oblivious of the call, and after exiting the store and leaving the parking lot, police officers pulled them over. When Mr. Wallace asked why they had been stopped, an officer told him that the manager at Costco accused them of robbery. As it turns out, there was no robbery, there was no crime, and just a regular Maryland couple looking to purchase a new refrigerator for their home. The act of placing false 911 calls against individuals based solely or in material part on the color of their skin perpetuates racist and discriminatory stereotypes and further sows the distrust between law enforcement and members of historically marginalized communities. It is also a waste of public resources that could be directed toward addressing actual crimes rather than false ones. Like other states, such as Oregon, Washington, Maryland must be proactive in discouraging and deterring this abhorrent behavior, which has led to and will continue to lead to serious consequences for victims and even possibly death. We must take this action to hold individuals accountable for weaponizing discrimination and personal bias by misusing law enforcement and the emergency calling of 911 to harm others. I know that State's Attorney Schellenberger is here as my lead proponent, as well as Zainab Chowdhury. And I'm not sure about the NAACP, but I'm happy to take the questions after their testimony. Thank you.
Excellent. Thank you, Senator Carter. So we'll now move on to Mr. Schellenberger. You're up. Good to see you. All right.
Mr. Chairman, Mr. Vice Chair, members of the committee, so good to see you all for the first time this year. I'm here again in support of Senator Carter's bill, Senate Bill 151, hate crimes, false statement to law enforcement. I think Senator Carter outlined the reasons for this very succinctly. The incident in Central Park, where an individual was accused of threatening a woman, which turns out to be not true, clearly was racially motivated. Another case happened in a New York City hotel where a young African-American man was accused of stealing an iPhone when in fact the woman had the phone and just didn't, or had dropped the phone and hadn't realized that. It was quite clear when you watched these incidents and read about them that the individuals made a direct false statement and it was based solely upon the race of the potential defendant. So you may ask, well, why do we need to change this? There's already a false statement statute. Well, the problem is a simple false statement to a police officer carries a maximum penalty of 6 months. If we upgrade this to make sure that those who are motivated by a bias concerning a person's race, color, religious beliefs, sexual orientation, gender identity, disability, national origin, or even, as you added a couple years ago, homeless, if we move that to this statute, then it calls for a sentence, if it's a misdemeanor, of 3 years. And we think that gives it the seriousness that it deserves. And again, we as the prosecutor must prove beyond a reasonable doubt, and that is a standard that I accept in this case, must prove beyond a reasonable doubt that that is your motive. That's right in the beginning of 10304, that your motive is based upon that. And that's a pretty high standard for us to meet, but one that I accept and one that I think is very important. We think this is a good statute. We think that there are examples that have happened, and we think it's needed, and therefore I support Senate Bill 151.
Thank you very much, Mr. Schellenberger. We'll now move on to Ms. Chowdhury. You're up next. Welcome.
Good afternoon. Thank you so much, Chair Smith and members of the Senate Judiciary Committee, Judicial Proceedings Committee. It's great to see all of you virtually at the beginning of the year. I hope you all and your families are doing well. On behalf of CARE, the Council on American Islamic Relations, I thank you for this opportunity to testify in strong support of Senate Bill 151, sponsored by Senator Carter. In recent years, as Senator Carter mentioned, we've seen a significant uptick in the number of reports of racially and religiously biased motivated 911 calls across the nation that have gained national headlines. And I won't go into the specific examples of the calls that we have seen. Many of these have made national headlines, as Senator Carter mentioned. And these are only a few examples of the high-profile national incidents that have taken place. But my organization has also received numerous concerns from community members right here in Maryland who feel like their race or religion have been weaponized by individuals who harbor bias or animus towards them. Some community members report changing the way that they behave or the way that they dress when they go out in public because they're afraid of being targeted. There was one family in particular who reported to us that they even moved out of their predominantly white neighborhood because they were afraid of being targeted because of a series of incidents that had happened that led to them being afraid even to leave their house at one point. We believe that the function of law enforcement agencies is to protect and to serve, and the 911 system was established by AT&T, as we might know, in 1968 after the FCC met with the corporation to explore a means to create a universal emergency number that could be rapidly implemented. Its designated purpose is to summon the police in case of a true emergency. Unfortunately, we know that that's not always the case, and too many people unfortunately feel entitled to be able to exploit the system to make these agencies complicit in their bias. We strongly feel that it's time for the Maryland General Assembly to take action and prevent these kind of dangerous calls that in some cases can also potentially risk someone's life. Unwarranted 911 calls and non-emergency situations are a waste of taxpayer money, of resources, and they endanger the lives, especially of communities of color who are directly and disproportionately impacted by them. Therefore, we support this bill. We believe it sets the tone for accountability, and we believe that it will help discourage this kind of behavior in the future. So we respectfully urge a favorable report. Thank you for your consideration.
Excellent. Thank you very much. All right, next we'll look to committee. I see Senator West. So Senator West, you're up.
Thank you, Mr. Chair. I think I need to ask the same question I asked last year, but I don't remember Scott Schellenberger being here that last year, so I'll ask it of Scott. As an estate senator, I frequently attend community association meetings, and they always begin with a uniformed officer giving the local crime report. And then when he's finished or she's finished, questions are asked. And so frequently, a question is responded to as follows. The officer says, look, if you see something suspicious, call us. Don't deal with it yourself. Call us. We'll come check it out. So here's your hypothetical. You've got an older lady who's sitting in her living room of an afternoon, and across the street from her is one of those courts that we have so many of in the greater Towson area, where you enter the court and you don't go too far before you have a turnaround area. And there are probably 8 houses around the sides of the court. So she sees 2 people who she does not recognize as being neighbors come up and enter that court and go into the backyard of one of the houses. So if she's doing what the officers told her, she's going to call the police. Now, let's hypothesize 2 situations. One, the 2 are white. Second, the 2 are black. Is she going to, if this bill is passed, is she going to encounter problems if she made that call with the 2 black youths going into the back of the house, as opposed to the 2 white youths going into the back of the house?
I would say no. And the reason I say no is because, remember, she has to be motivated either in whole or substantial part. That's what 10304 says, by one of those reasons. So if she just says to the officer or 911, I just saw 2 strangers walk into the backyard of my neighbor, that does not show that she's being motivated by any of those categories. And certainly with what you just said as an example, I don't think I would be able to prove that. The key element to, and the other thing is, if she says they just went into the backyard, remember, it's a false statement based upon the motivation. She didn't make a false statement. She made a legitimate statement as to what she saw. And that's the difference with the other 2 cases from New York. They made false statements, and it was video that was able to save what I would call the victims of the crime, the people they were accusing. So you have the 2 factors. She needs to have made a false statement. Your example, she didn't. And I got to prove beyond a reasonable doubt what her motivation is. And the language that you used did not indicate any sense of a motivation.
Good answer. Thank you very much.
Thank you, Senator West. I've got a question as well, but I think I skipped Steve Kroll. So Mr. Kroll, and in fact, the question would be to both of you, to Schellenberger and Mr. Kroll, but sorry about that. Mr. Kroll, you're up. Sorry for that. You're unmuted, but we cannot hear you. Oh, now you're muted again. We cannot hear you.
He was going to say something even smarter than what I said.
He's always brilliant. So we'll just assume we'll give him the benefit of the doubt. All right. Well, while he's figuring out some of that, we'll keep work on the technical issues. I had a question, I guess, for Mr. Schellenberger then. And Senator Carter, thank you again for bringing the bill, and thank you to the panelists. I spoke to your cross file about this over the interim, and I just couldn't. I'm trying to figure out how this part of the statute works, because I like the bill, and Senator Carter, as you pointed out, obviously filing a false police report already there. So all right, that's different. So what this does is it slides it under. It makes this a hate crime. And this part of the statute, I just don't know how this part of the statute works, because if you are committing a crime, which filing a false police report is, against someone because of their protected status, then why is it not already incorporated into this part of the statute? Because you literally, Mr. Schellenberg, you read it. You said commit a crime or attempt or threaten to commit a crime against that person or group. So I like it. I don't know how this part of it, I don't know how it functions. So if you could just help us.
I got you. So you got to read the first part and 1, 2, and 3 together. So motivated by one of those reasons, you commit a crime or attempt or threaten to commit a crime against that person. So that means if you have one of those statuses, you're the victim. So I've attacked you because of your gender, because of your gender identity, because of your race. So I've attacked you. So it's the opposite. That's what the problem is. And then the next one is deface, damaged, or destroy, and the property of the person who's a protected class. So this would be if, I went after in Senator West's example, if I blew out the window of the car of that couple who had walked back there, then that person could be prosecuted for a hate crime for that. But it does not make it a crime for it to be the person who's reporting the crime based upon hate. So it kind of flips it, if you see what I mean. So that's the difference, and I hope I cleared that up. Judging from the look on your face, I may not have.
No, clear as mud. No, I'm kidding. It seems it's because you're committing a crime. That's a crime that you're doing. You're filing this false report, and that's the crime against the person, or so I would initially think.
Well, it always was a crime. It was just a regular false statement.
But it's because if I'm black, right? So let's say it's because of my race. If you're doing it because of my race, doesn't that slide this into this part of the statute?
No, because you got the people backwards. So it's like if they commit the crime, if they commit the crime based on race. So that is if I attacked you, but does not, I don't think, encompass the false statement. And that's the whole idea of trying to take it up to another level by putting it in this statute and in a sense, taking it out of the other one.
Got it. I think. I just thought that the crime of committing the false statement because of my race would be enough, but I understand what you're saying. Okay. Got it. All right. Well, Senator Castley, I think you have a question.
Thank you. So I applying this to me in the case of like race, religious belief, that's easier to do. The one that's causing me some trouble is gender. Oops. Am I muted?
No, you're good. We can hear you.
Okay. I had a thing popped up. I'm thinking that that's going to be difficult to apply because, everybody has a gender. That includes everybody. So if a man makes a claim against a woman or a woman against a man, almost certainly in most cases can be, why did you do that? I didn't like her. She dissed me. She turned me down. He, whatever. It seems like there's going to be that one that swallows the entire rule here, that every false statement that relates to someone taking violence or is going to bring this in the case of gender, won't it?
Well, no. Remember, I have to prove beyond a reasonable doubt that it's false and that it's been motivated by the gender. And so typically, I'm going to have some kind of language or words out of the defendant. I'm doing this because you're a woman. If you were a man, I wouldn't be doing this. I don't think I'll ever get a case that clean, but I certainly do believe that you could have a case where an individual has committed a series of acts against a woman, and I have been able to prove that he's only doing it because it was motivated by the gender of the victim. I would say those cases are fewer and far between, but the word gender has been in the statute since the beginning.
No, I got that, but it didn't apply to false statements. You had to actually do something. I hit you because you were a woman. I shoved you down, but now it's the false statement or a
but
man.
It's false statement to a law enforcement officer,
Right.
such that it's going to get you in trouble, and it is motivated by the gender. And so we have a lot of steps here. You know, we're calling 911. We're talking to the police officer at the scene. We are saying something that is absolutely false, and I can prove that it's motivated by a discriminatory reason on gender. That's a lot of steps for me.
But why doesn't that bring in every spat between people, the ex-boyfriend, ex-girlfriend, ex-spouse, current spouse? They're all, it's the relationship is based upon genders, and seems like every false statement by the jilted lover is, I mean, the relationship was based upon gender. So wouldn't that include all of those suddenly become felony complaints? Look, I have no problem these motivations based upon race, right? Where coming after, I'm trying to get this black kid arrested, something like that. That's a little easy to wrap the head around, but it just seems to me that this is going to make every false statement of jilted lovers or angered boyfriends and girlfriends, whatever, is going to suddenly become a felony, because you wouldn't have done it if it was the guy from your beer party. You did it, and let's face it, your whole relationship is based upon gender. So every time these people get pissed off at each other and try to make a false, try to get even, suddenly they're in felony land instead of misdemeanor land.
Well, I believe that it only goes to a felony if it's one of the other ones. But Senator Carter, maybe you can help me here.
Sorry, go ahead, Senator Carter. There.
Thank you. Well, yeah, this section of the bill is only a potential fine and misdemeanor 3-year incarceration. It's not covered in the felony part. The felony is a different section, covers a different section, but a different thing. The other thing, I understand what you're saying, Senator Casserly, and certainly we know that routinely in intimate relationships, there are accusations that flow, but I actually disagree with you that they're based on gender. Even if the relationship is one between people that are of different gender, like State Attorney Schellenberger has repeatedly said, the motivation has to be based on that. Usually these disputes are based on, some other aspect, like a jilted lover or someone that's rejected or just angry about something, but the motivation for filing a report is not because the person is of the opposite sex or a different sex, a different gender.
And Senator
Well,
Cassidy,
maybe Senator, maybe
look at
Mr.
number
Schellenberger
one.
is correct. Maybe I'm misreading it. I guess it does say a misdemeanor unless it does involve the death or it's a separate crime, but that's a felony, right?
Right.
Still retains a misdemeanor.
Correct. And
Okay.
and the other thing is the statute has for years had gender as one of the factors. And so if the ex-boyfriend had smashed the window, right, they could have alleged that it was a hate crime. And I can tell you, we don't see those. They don't charge that. Even if the victim lied about who did it, we wouldn't be able to necessarily prove that it was based on the gender. It's what Senator Carter said, is it was based on the relationship. So I don't, first of all, it's a misdemeanor. And second of all, I think this is a hole in the law that I think we need to fill.
Okay, thank you, Mr. Schellenberger.
All right, thank you very much. All right, with that, seeing no further questions from the committee, thank you, Senator Carter, and thank you to the panel. It's been very good. Thank you very much. We'll work on this. All right, so with that, that'll conclude the hearing for Senate Bill 151, and we'll now move on to Senator West with Senate Bill 44. Senator West, are you ready? There you go.
Yes, I am. I was expecting 49 because it dealt with similar subject, but we'll go with 44 instead.
If you'd like, we can go to 49. I think your guest or your panelists are here for 44. So let's.
Fine. Well, let's go with 44.
Excellent.
Chairman, members of the committee, it is indeed a pleasure to present my first bill of the year. This bill is entitled Crimes, Unattended Dogs, Extreme Weather and Conditions and Heat. This is a bill you've seen before, but this year's version is a little different from the version you've seen in past years. I want to start by thanking Senator Sidner for co-sponsoring the bill with me. I believe I speak for most when communicating that pet dogs are an invaluable companion to human beings. In addition, they assist the blind, they comfort veterans with PTSD, they detect bombs. In short, dogs empower us, making our lives safer, easier, and mostly happier. That's why it's important to take their well-being seriously. Dogs left unattended in extreme weather and without access to adequate shelter are at risk of hypothermia, heat stroke, injury, or even death. As of 2021, 10 Maryland counties recognize the risks for dogs left in extreme weather conditions and require them to be brought indoors or require that adequate outside shelter be provided for them. The remaining jurisdictions in Maryland do not have such laws. Let's deal with extreme heat first. Senate Bill 44 makes it illegal for a person to leave a dog unattended for over a half hour without suitable shelter or suitable shade when temperatures are above 90 degrees Fahrenheit. Now, the shade provision was not in this bill last year, and I asked some critical questions and wondered whether or not the bill last year was going to require people who own dogs and wanted to let them go outdoors in the summertime was going to require those people to either buy or build dog houses. This year, we've added shade to the bill. So as long as the dog is outside unattended for over a half hour, when the temperature is over 90 degrees, if there's adequate shade so the dog can lie in the shade, either under a tree, under a bush, behind a building, in a garage, whatever, that's okay. In addition, it would be, under the bill, be illegal to leave a dog outside unattended and without suitable shelter for over a half hour in what the bill describes as extreme weather conditions. And that is below 32 degrees Fahrenheit or during an active warning issued by a National Weather Service. Suitable shelter in the bill, it's defined as a dog house with a doorway and a waterproof roof. The key is insulated to allow the dog to maintain its normal body temperature. So if you're going to put a dog outside in the middle of the winter on a frigid night where the temperature is below 32 degrees, so long as the dog has a dog house, which is sufficiently insulated that the dog can maintain its body temperature, that's okay. But if not, then it would be illegal under the law. Suitable space is specifically described as not a crawl space under a building or a space under a vehicle or a floor consisting of wire or chain link or easily degraded materials like cardboard. Senate Bill 44 provides that a person in violation of this law is guilty merely of a civil offense. And the first time the person is cited, it's nothing more than a warning. The second time, it would be a $500 fine, and the third time, a $1,000 fine. The bill also has comprehensive exceptions and will not apply to dogs actively engaged in hunting, protecting livestock, sledding, sporting, or training. Last year, the House version of this bill passed on the floor of the House 121-9. The Senate version of the bill never got voted on, in part, I think, because I asked the questions about shade, which this bill attends to. This bill is a minimal measure that's just plain common sense. It'll have little impact on the daily lives of most Marylanders, but it will ensure the well-being of man's best friend. Most of the complaints would be lodged by next-door neighbors who will see a dog sitting outside on a brutally hot summer day with no shade, or a brutally cold winter night, and would hear the dog whining and barking because the dog is in extremis. So under current law, if a police comes to a house, the police has, and the county has not passed a similar bill, there's nothing the policeman can do. This law would put on the books for provision which would enable a law enforcement officer in every case, in every county, to issue a citation upon the first offense and warn the homeowner, the pet owner, that he needs to be more careful or she needs to be more careful at how the pet is attended to. I would also note that the bill does contain a provision at the end that says counties are entirely at liberty to enact local laws which would be more significant than this law. This would provide the base below which a county could not go. So I appreciate the committee's consideration of Senate Bill 44 and will be more than happy to answer any questions.
Excellent. Thank you, Senator West. And I appreciate you bringing the bill forward again and working on it. 'Cause I know we've been I had this bill once upon a time, and we've been working on it for years. So, and you have an all-star panel here. So we'll start off with Ms. Bevan Dangle. We'll start off with you. And then Senator Cassidy, I see your question. We'll hold off to the end of the panel.
Good afternoon, Mr. Chairman, members of the committee. I want to thank our sponsor, the chair, and all of the members who have helped us continue to work on this bill and improve it over the years. It is certainly in a different posture than it started, but we think that this year we've got it right. We do hope we've threaded the needle just so. I apologize. My name is Jennifer Bevan Dangle, and I'm the state director for the Humane Society of the United States. As the sponsor has very well explained the legislation, and I know that this is not a new bill for this committee, so I'm going to focus on all of the changes from what you saw last year, because while the shade amendment was the most significant one, we do think that there are several provisions that addressed additional concerns this committee had raised. The first change is that the types of weather advisories clearly exclude marine advisories. This was raised by the committee staff or the chairman. You know, certainly a fog advisory we don't think necessitates a dog to be in a dog house. Dogs can handle fog. The second amendment is this shade amendment. So it acknowledges that in hot weather, if it's not quite a heat advisory, shade can be quite sufficient as long as it fully covers the dog. The Humane Society is comfortable with this language, and we think that it does address some of the concerns that were raised last year. The next two changes really have to do with concerns raised, in part by Senator Bailey and others from our farming communities, that the first being dogs that are actively herding or guarding. So it was flagged that actively herding might not adequately cover livestock guarding dogs. We're aware that dogs that are engaged in livestock guarding do have access to the same shade and the same shelters that are already required for the farm animals. Those shelters, if they're adequate for the farm animals, are adequate for the dogs. We wanted to make that clarification. And then lastly, very related, there was a flag that a barn that has padded stalls and straw and sawdust, and it's again amply sufficient for livestock, would not have been adequate. So it can be elevated or insulated flooring. So with those changes, we urge this committee's support.
Excellent. Thank you very much. And next we'll move on to Ms. Swanson. Swanson here. There you are.
Good afternoon, everyone. My name is Jen Swanson. I'm the Vice President of the Professional Animal Workers of Maryland, and we are the state organization comprised of Maryland's animal control agencies and shelters. And I'm also the Executive Director at the Humane Society of Harford County, and I was formerly the Executive Director at the Baltimore Humane Society in Baltimore County. I'm testifying today in my capacity in both roles, asking you to vote favorably on SB 44 to protect unattended dogs in extreme weather conditions and heat. The PAWS president, Patty Quimby, has already submitted to you the written testimony on behalf of PAWS, which I will not read over. However, I do want to pull out an important piece to note, which is that this bill simply brings our state in line with what is recommended by reputable national organizations such as the American Veterinary Medical Association as a minimum standard of care for dogs in extreme weather and heat. This minimum standard does not exist in state law. And why is that important? It's important because in counties like Harford, there are no existing protections for dogs left outside during these weather events and extreme hot and cold. By creating the state law, we're creating the minimum standard by which all county agencies can operate within. And if a county wishes to enhance the law, they certainly can, but this basic minimum standard we believe should be in place at the state level to protect these dogs which cannot speak for themselves. Any one of us who work in this field can stand here and recite case after case of animals in various stages of distress, and in some cases resulting in death due to these weather conditions. We can rattle off the hundreds of calls that we get each year during these events from upset and concerned citizens who don't understand why we can't do more. And frankly, we wish ourselves that we could do more. Sorry, this is very, very emotional for us. This law will allow us to do the two main objectives of any animal control agency or sheltering agency better, and that is to protect animals and serve citizens. It's just very simple. It's just that. So thank you again for your time. We urge the committee to vote favorably on SB 44 to protect dogs in extreme weather events.
Excellent. Thank you very much. And next we have Ms. Stone-Hess. Ms. Stone-Hess here. All right, I don't see Ms. Stone-Hess. Then we'll move on to Lisa. Ms. Right up, you're up.
And I don't see her in the waiting room.
Okay, great. Thank you.
Good afternoon, Chairman Smith, Vice Chairman Waldstreicher, members of the Judicial Proceedings Committee. Thank you for the opportunity to testify before you today. Lisa Radov from Maryland Votes for Animals. I'm the president and chairman of this organization that supports humane legislation to improve the lives of animals in Maryland. We are here in support of SB 44. And yes, Senator Smith, you absolutely did work on this bill. It was back in 2015. I even just got a notification on Facebook about it, if you can believe that. So you've already heard excellent testimony from my colleagues, boots on the ground from Ms. Swanson, about animal officers and how they're called, usually at the very last point. Establishing guidelines about dogs left outdoors enables animal control to intervene before dogs show symptoms of acute distress. Moreover, adding clarity to the law can foster both public awareness and compliance, which could potentially avert some of these life-threatening situations before they occur. Let's make 2022 the year that we finally get protection for these dogs suffering outside in extreme weather and heat. We spent a lot of time after last year's bill with this committee, with the chairman, and very much would like to thank Senator West for stepping forward with excellent input. And yes, we're throwing some shade in this bill, we can say that. Would like to ask for your support on SB 44 and ask for a favorable report. Thank you.
Excellent, thank you. Talk about throwing shade. Those dog memes, on Twitter were just awful. Anyway, all right, we're gonna go. We have Fernando, you're up next. And then Mr. Hall, is Charlie Hall here? All right, there you are. So, okay. Excellent, go ahead.
Good afternoon, Mr. Chairman, Mr. Vice Chairman, Senator West, and committee members. Thank you for this opportunity to be heard. My name is Fernando Guerra. I am the chair of the Maryland State Bar Association Animal Law Section. And on behalf of the section, we urge a favorable report on Senate Bill 44. Dogs are faithful and loyal companions, but beyond their companionship, they also provide us many things as a community, including invaluable assistance to individuals that use service animals. They also provide larger benefits to the community at large, such as dogs that work with law enforcement and search and rescue, as well as military individuals. And what makes dogs so extraordinary in all these capacities is their ability to feel. That is, their sentience and their sensitivity is what makes them so unmatched in these roles. So this bill aims to protect that sentience and that sensitivity that dogs do possess and that benefit us so much as a society. This bill is ensuring that we act as good owners and stewards of our canine friends. And for that reason, again, we urge a favorable report on this bill. Thank you very much for your attention and time.
Thank you very much. And then we'll wrap up with Mr. Hall. You're up. There you go.
Okay, for the record, Mr. Chair, I want to let you know that I am favorable with amendments.
Got it. Yep.
Chair Smith, members of the Senate Judicial Proceedings Committee, my name is Charlie Hall with the American Kennel Club. I appreciate this opportunity to voice our concerns with Senate Bill 44 as it is currently written. I would like to thank Senator West for taking the time to personally discuss our shared concerns about the well-being of all dogs. Since I have submitted written testimony which provides greater detail, I would like to highlight amendments that we believe improves the bill and better protects all Maryland dogs. Did you know that dogs are the most diverse species of mammal? So much diversity means that each dog's needs are different. Yet this bill treats them all the same when it comes to extreme weather. One size fits all legislation to protect dogs from inclement weather without consideration of other factors related to age, breed, health, etc., ignores that some breeds require a more moderate climate, and even 30 minutes in cold or hot temperatures could jeopardize their health. We recommend the following. Amend the definition of extreme weather conditions to include language similar to Baltimore County's ordinance definition of adverse environmental conditions, which adds other cold weather or precipitation related environmental conditions that a person should reasonably conclude would pose an adverse risk to the health or safety of a dog based on age, breed, etc. Agreeing with the American Veterinary Medical Association guidelines for the protection of dogs in summer months that include making sure dogs have access to shade when outside. We would recommend adding language, as Senator West had indicated he may be agreeable to, that require suitable shade during specific warmer weather periods of the year, as several Maryland counties currently do. Given the diversity of breeds and to ensure that no dog is left in conditions where its health and safety is at risk, add language allowing an animal control officer to determine if the dog is safe and well suited to tolerate its environment based upon their inspection. This would allow a trained professional to make the determination instead of an arbitrary number on a thermometer. Finally, while we are pleased with the existing exemptions, we recommend that acclimation be added to the list. Anytime that a trained dog may be called upon to perform a specific task in adverse conditions, the dog must first be acclimated to those conditions. Again, AKC agrees with the goals of Senate Bill 44 and are grateful and appreciative that it will protect some dogs in the state of Maryland. However, we believe the changes we have suggested would ensure that all dogs are protected. Thank you for considering both my written and oral testimony.
Thank you very much, Mr. Hall. And we'll now go to Mr. Apple. And then I believe Hess is in the room. So Mr. Apple, you're up next.
Thank you very much, Mr. Chair. Mr. Vice Chair, committee members, good afternoon. My name is Chris Apple. I live in Columbia, and I'm not a lawyer or an animal rights activist. I'm just an ordinary citizen who loves dogs. So I'm testifying today to let you know that ordinary citizens like me do have interest in seeing this bill pass. I frequently dog sit a very sweet pit bull named Kaylee. And when we let Kaylee out, we are very careful to keep an eye on her. But unfortunately, not everybody watches their dogs as carefully as we do. I'm a lifelong Maryland resident, and pretty much everywhere I've lived, there's been one person or several people who leave their dogs out in all kinds of extreme conditions, extreme cold or heat, or barking long hours into the night. And I think people either think that their dogs can handle the weather and the cold, or some of them, unfortunately, just really don't care what happens to their animals. And in some parts of Maryland, as we've heard already, there's very little that animal control or anyone can do about it. So though many well dogs are looked after, there are dogs like Oscar who are routinely neglected. Oscar, as you may recall from previous year's testimony, was a dog who unfortunately died from exposure due to the elements. And ultimately, it was a deficiency in the law that stopped Oscar from getting help, as several Good Samaritans did call the authorities to get some assistance. But legally speaking, there was nothing anyone could do about it. So they had to just sit back and watch. So today I'm asking the committee to finally make this the year that this bill gets passed, to please issue a favorable report to protect those neglected dogs who can't advocate for themselves. Thank you very much.
Well, thank you very much, Mr. Apple, and thank you for your patience. All right, next, I think Ms. Hess is in the room. Sandy, is that right? I cannot find her on the Zoom screen.
Yeah, I've just asked her to unmute.
Okay, there you go.
Yes.
There you go. Ms. Hess, there you are.
Hi, can you hear me?
We can. Success.
Perfect. Thank you so much. Good afternoon, and thank you for the opportunity to speak today. My name is Deborah Stone Hess. I chair the Baltimore County Animal Services Advisory Commission. Our commission was created by the Baltimore County Council to advise on Baltimore County Animal Services, which is our county-run shelter, which brings in about 5,000 animals every year. And on behalf of our Animal Services Advisory Commission, I request a favorable report on Senate Bill 44. In 2018, the Baltimore County Council passed a bill that is the inspiration behind this Senate bill, and it's called Oscar's Law. You just heard a moment ago about Oscar. He died of hypothermia while lying in sub-freezing temperatures in the snow in his Baltimore County yard. Subsequently, the Baltimore County Council passed Oscar's Law, which is very similar to SB 44. So Baltimore County decided that its citizens must be responsible for preventing such a tragedy as Oscar's by ensuring that animals have appropriate shelter from intense heat and cold. Animals throughout our state deserve these protections and will receive them if Senate Bill 44 and its common sense requirements are approved. Pet owners, of course, have a responsibility to care for them and for their animals and not put them in harm's way. Unfortunately, some pet owners do not take these responsibilities seriously. With the passage of SB 44, they will be required to provide basic protections from extreme heat and cold so that other animals do not die like Oscar did. Please vote favorably for Senate Bill 44, and by doing so, you will become a protector of helpless animals in the state of Maryland. Thank you so much again for the opportunity to speak to you today.
Excellent. Thank you very much, Ms. Hess. And with that, that'll conclude the testimony for Senate Bill 44. We'll now switch to the committee for questions. Senator Castley, I seem to remember you had a question. Okay, great.
Yes, thank you. I just really for the sponsor, I think you can just explain it to me. On page 3 of the bill, Senator.
Sure.
Page 3, line 15, 16, 17. That's where my question is. Really, so as I look at line 13, that requires suitable shelter during extreme weather conditions, which is basically the cold weather. That takes care of the cold weather side of it, right? Freezing weather, freezing.
Yes, that's 13 and 14. That's right.
Right. And then number 2 says suitable shelter or suitable shade when temperatures are above 90 degrees Fahrenheit. Got it. But below what is required for heat advisory. I just don't understand trying to understand how that plays in.
That's a good question, and I don't know the answer to that. So I'm going to turn it over to Jennifer. Do you know how to answer that question?
Yes, thank you, Senator. And my fingerprints are certainly on some of the drafting, so if there's an error, I take a lot of the blame for that. The intent here is to ensure that we're not requiring the shelter when it's hot, but not yet a heat advisory. So extreme weather is defined as both your extreme cold, if you look at page 1, lines 19 through 22. Extreme weather means both below 32 degrees or during an active weather warning or advisory. So this would be hurricanes, derechos, the ice storms we've seen, and then of course your extreme heat advisory. So if the local area, if the resident is facing that type of extreme weather situation, then the shelter is required. But if it's simply hot outside, the bill with the second piece that you would flag on page 3 will allow for shade in that hot weather, but it's not yet extreme weather.
So extreme weather would include, this says active weather warning or advisory. So it would include a heat advisory.
Yes, sir.
So under this, so I know they come in the summer and they say it's the heat advisory and it's going to get very hot and we all should scale back on what we do and stay in the shade, right?
Well, we should seek a suitable, usually shelter to make sure that we're not allowing ourselves to go, into overheated conditions.
Right. So he didn't hear me out. Then I had understood that what we were doing was that, look, if it's freezing temperatures, then it's got to be a suitable shelter because to protect the dog, you got to have this suitable shelter. It's going to insulation to allow the dog to maintain its normal body temperature, which you got to do, right? I mean, it's got to be, you have to put them in something that maintains that. So I got that. So that's freezing. But I understood that the gist of the bill was that if I have a backyard with one of those 100-year-old oak trees that shades the entire backyard with a heavy canopy of leaves, and that it's okay to have the dog sitting under that big oak tree. But now what I'm understanding is no, if it's a heat advisory, you got to put them in a doghouse.
So if it's hot weather, then that tree is going to provide sufficient shade for the dog. And we are confident that this bill will still keep dogs safe, even with, saying you can be in the shade. Once you get to a heat advisory, that shade is no longer sufficient to maintain the dog's regular temperature. And so that's why the secondary provisions, you have to make sure that the dog is being, adequately protected once you get into that extreme heat. Just like my kids can't sit under the tree in a heat advisory for more than 30 minutes. I wouldn't want to be leaving dogs at risk of heat stroke because we continue to allow the shade even as it got into this heat advisory. It's freezing cold outside, so it's very hard to think back to warmer months, but we've all seen, how with our humidity, just how significant the heat can be. And the shade doesn't do anything for humidity.
Yeah, I'm just trying to, if you have outside dogs, a lot of people have outside dogs. So what this is saying is when there's a heat advisory, your outside dog has to become an inside dog. They have to come inside the air conditioning in the heat advisory.
No, it just has to have shelter that meets these standards. So to put a really clear example on this, we had a case where some dogs were living in the burnt out remains of a house that had burned down. That under current law was determined to be sufficient shelter, even in the hot weather, even though we're talking about burnt out scraps of plywood. A dog who is actively hurting is going to have access to, structures that are there for the livestock. My dogs could be outside with an insulated and shade, insulated, elevated structure. So it's not saying your dog has to come inside. There's still a lot of options here as far as what types of structures are going to be permitted. But what it's saying is that you have to have a suitable shelter. There has to be some type of definition once we get into a heat advisory, because those can be just as deadly as the freezing cold.
Yeah, I'm trying to picture a suitable shelter is defined here pretty much as a dog house. I'm trying to picture how I'm trying to picture a big dog going inside of a dog house when there's a heat advisory, how that's going to possibly be cooler than lying under the shade of the big oak tree. But this says, no, that's not good enough. He's got to come inside of something to deal with the heat advisory. And a lot of us who have big dogs that spend most of the time outside do quite well just lying very still under the big spready oak tree and not running around when there's a heat advisory next to a big bowl of water.
There's actually a lot of structures that would be covered under the bill, especially with the insulated floor amendment. My back patio is accessible to the dogs when they're in the backyard. It has 3 sides. It has a roof. It has insulated flooring, thanks to the previous owners who wanted a very nice patio. And the dogs could be on there, and they're protected in the hot weather. There's a lot of options, but the shade alone, shade does not protect in that heat advisory when it is as humid as Maryland summers can get. And so that's really just the trigger here.
Yeah, I'm just trying to understand how your dog lying on the back patio under the shade awning is better than my dog lying on the cool grass under the spready oak. But you're saying mine's not good, but yours is in the heat advisory.
We're saying the shade is not going to be a tight enough protection for our dogs. That shade can be dappled sunlight. The sun can move as the day progresses, and that shade can change in its quality. And so that definition just remains too vague for when we're into these heat extremities. And if the dog is under supervision, none of this matters. So if you're in the house and keeping an eye on him, none of this applies. So it's really just in these extreme heats, extreme humidity, where we can't guarantee that shade is truly going to protect our four-legged companions.
Yeah. I'll just submit to you that the sun's going to move on your dog on the patio just as much as the sun moves on my dog under the 100-year-old spready oak that's is bigger than your entire house. But okay, thank you.
All right, thank you, Senator Castley. We'll now move on to Senator Hettleman. You're up.
Thank you very much, Mr. Chairman. I don't have a question. I just wanted to recognize that some of the main advocates of this bill are constituents of mine, and I just want to thank them for all of their work at the county level and now bringing this to the state level. Ms. Radoff and Ms. Stone-Hess. Thank you.
An all-star panel indeed. Some of my favorite people on the panel. All right, excellent. Seeing no further questions from the committee, That will conclude the hearing for Senate Bill 44. We'll now move on to Senator West with Senate Bill 49. Senator West, you're up.
Thank you, Mr. Chair. Wait a minute. There we go. I think I'm all set. Mr. Chairman, members of the committee, by the way, the sun seems to be right in my face. Can you all see me? This is that time of day when it's, let me keep moving around here, trying to get away from the sun. Why don't I just pull the shades down? Hold it. All right. That's as good as I can do, and I apologize for the delay. I'll have to take that into account in future days. So it's, again, a pleasure to present Senate Bill 49, which is entitled Criminal Law, Person in a Position of Authority, Sexual Misconduct with a Minor. Section 3-308 of the Maryland Criminal Law article currently precludes a narrow class of individuals who are in a position of authority over a minor from engaging in sexual conduct with that minor. The current law is limited to employees of schools who exercise supervision over students, and the protected class merely consists of the students. The current law is far too narrow. A recent case in Montgomery County exposed the obvious loophole in this law. The victim, then age 17, was receiving private music lessons from a teacher in his 50s. The lessons were conducted in the teacher's home, and the victim's father remained in an adjoining room during the lessons. Behind that closed door, the teacher engaged in sexual conduct and ultimately sexual intercourse with the victim. Even though the private music teacher was just as much a person of authority as a music teacher in a school would have been, because the offender was not employed by a school, no prosecution was possible under Section 3-308. The Montgomery County State's Attorney's Office properly examined the case and concluded that it could not prosecute. In Baltimore County, we had a similar situation. Is Scott still with us? Scott is with us. I'll let Scott talk about the Baltimore County situation. Suffice it to say, this situation is not unique to Montgomery County. It occurs with all too great frequency in other locations around the state. Senate Bill 49 attempts to close this loophole. It revises the definition of a person in a position of authority to include a person at least 21 years old who is employed by or under contract with or volunteering at a school, a child care program, an after-school program, an instructional program for music, dance, art, tutoring, academic enrichment, or martial arts, or any other program with a similar purpose. Also, a sports program, a scouting program, a recreational program, a camp, or a religious institution. This list represents an attempt to cover the waterfront of situations in which minors are being supervised by persons in a position of authority. The bill then provides that if such a person in a position of authority engages in a sexual act, sexual conduct, or vaginal intercourse with a minor who at the time of the conduct is enrolled or participating in the institution, program, or activity, where the person in the position of authority is employed or volunteering, such a person in a position of authority is guilty of the misdemeanor of sexual defense in the 4th degree and is subject to a year in jail or a fine up to $1,000 or both. The bill goes on to provide that even if the minor has ceased to be enrolled or participating in the institution, so long as the minor remains a minor, the person in authority still may not engage in a sexual act, sexual conduct, or vaginal intercourse with the minor, so long as the minor remains a minor. In summary, this bill is a robust measure that comprehensively protects minors from predatory sexual advances by persons in a position of authority over the minors. I appreciate the committee's consideration of Senate Bill 49 and would be happy to answer questions.
Thank you, Senator West. We'll now move on to your panel, and we'll start off with Mr. Schellenberger.
Mr. Chairman, thank you so much. I'm going to go fast because you have some very, very good subject matter prosecutors coming up who I'm sure will be able to give you examples from each of their counties. I'm here in favor of Senate Bill 49, person in position of authority. We added this to the sex offense statute when we had a case many years ago dealing with a school employee and unfortunately a teenage girl. And we zeroed in on people who are in a position of authority who are in the schools. The problem is, in this day and age that we all have, our minor children are so involved in so many other things, whether it's an art group, a scout troop, sports teams, music groups. And the example in Baltimore County that we just had a couple years ago, which is why Senator West and I worked on this bill, was we had a fencing coach at a private fencing facility. The fencing coach offered to drive the 16-year-old female home who was taking the fencing lessons after practice. The parents agreed. He would drive her to a remote area where they would have sex and then drop her off at her house. He was found not guilty of what we would call our normal sex offense charges, like fourth degree and other things like that. And because he was not her teacher in a school setting, there clearly was not an ability to file under this statute. But clearly, he was in a position of authority with regard to this young lady. She obviously had a tremendous amount of respect for him. She was learning a lot from him. We tried to proceed under a regular fourth degree, but there was very difficult time with the issue of consent. And certainly it doesn't make sense that had he been a teacher in a school, we could have charged him with this crime, but because he was the fencing teacher after the school, we could not. We think that we need to fill this in, and therefore I support Senate Bill 49. Thank you very much.
Excellent. Thank you very much, Mr. Schellenberger. And we'll move on next to Ms. Marsh from Charles County State's Attorney's Office. And Ms. Marsh, we'll go with you next.
Good afternoon again, Mr. Chairman and members of the committee. I am Catherine Marsh, the Special Victims Liaison with the Charles County State's Attorney's Office. And on behalf of the Charles County State's Attorney's Office and the Maryland State's Attorneys Association, I urge a favorable report for this bill. When we consider consent, we often look at whether the person said yes or no, but we forget to look at whether the question should have ever been asked in the first place. When it comes to individuals who hold positions of authority over a minor, the questions and actions should never occur in the first place. This bill fixes that oversight. Further, this legislation brings us closer in alignment with almost 30 other states that have expanded definitions for position of authority. Two cases I've handled and was unable to charge immediately stand out. One was a young man in an Explorer program, and the other a young woman in a fashion design club. In both instances, my victims were 16. In both cases, the advisors were in their late 20s and early 30s. They began grooming the victims, first with text messages and DMs, then keeping them after the club for little things, then small touches, and eventually sex. If these actions had been committed by a school employee, I would have been able to charge. However, in these cases, the person in position of authority was not employed by a school, and I was left having to explain to the victims and their families why I could not charge. This General Assembly recognized the need to protect minors from individuals who hold positions of authority over minors several years ago. But we need to expand this definition to protect all minors from grooming and sexual abuse, whether that abuse occurs from someone employed by a school, a church, a sporting organization, or any other youth organization. And I urge a favorable return on this legislation.
Thank you very much, Ms. Marsh. We'll now move on to Ms. Feinstein. You are next from Montgomery County.
Good afternoon, Chairman Smith and members of the committee. It's nice to see you again. I am Debbie Feinstein. I am Chief of the Special Victims Division for the Montgomery County State's Attorney's Office, and I'm testifying on behalf of John McCarthy and my office. I want to echo what Senator West described with respect to the case in Montgomery County. The case in Montgomery County was one that happened actually close to 10 years ago. And I will tell you that I still hear from the father of that young woman that was victimized by her music teacher I'd say probably 3 or 4 times a year. He'll forward me an article, he'll forward me something that he saw or heard, really to emphasize how distraught he and his daughter were that we were unable to prosecute this case at the time. And the impact that this has had on her has been lasting. And it's why this year and in years past, I've come before this committee to urge a favorable report on this bill. This young woman, who was 17 at the time and was sexually abused by her music teacher, was no different than someone that may have been sexually abused by their public school teacher or their private school teacher, or someone that's currently under the definition of person in position of authority. It's the same dynamic, the same relationship, the same position of trust that was exploited when the music teacher developed this relationship with this 17-year-old. I've also had cases where we have individuals who are people in positions of trust, but not in care and custody of the child, which we would be able to prosecute under sex abuse of a minor, where literally the grooming process starts when the child is 14, 15 years old. And the individual waits until the child turns 16 in order to begin the actual sexual contact and sexual acts or sex with this individual, because they know that the age of consent is 16, and then it's no longer going to be a crime. We must change that. The grooming by a music teacher, a coach, an art teacher, individuals that are not currently delineated by the statute, is exactly the same as we see with our teachers and others that are currently included under the statute. I would urge a favorable report on Senate Bill 49. Thank you, and I'll be ready for questions if you have them.
Excellent. Thank you very much. We'll now move on to Ms. Carpenter from Frederick County.
Good afternoon, Chairman Smith, members of the committee. My name is Lindsay Carpenter. I'm an assistant state's attorney in the Special Victims Unit at the Frederick County State's Attorney's Office. And I'm here on behalf of the Frederick County State's Attorney's Office and MSIA requesting a favorable report on SB 49. SB 49 amends the definition of person in position of authority for fourth-degree sexual offenses. Currently, the definition only includes individuals associated with a school, such as teachers, coaches, or administrators. SB 49 recognizes the harsh reality that many sexual predators seek out positions that give them access to children in programs that are not associated with schools, such as extracurricular activities or day camps. Currently, individuals who exploit that power dynamic are unable to be held accountable, and SB 49 remedies this issue. For example, if a martial arts instructor were to groom a student from a young age, however, wait until that student turns 16 to engage in sexual activity because the predator knows that's the age of consent, that individual would unable to be prosecuted under the current law. SB 49 seeks to protect our children by ensuring that sexual predators are held accountable when they exploit a position where they were entrusted with the safety of our children. When an individual enrolls their child into a day camp or extracurricular activity, the last thing a parent expects is that their child will become a victim of sexual abuse. Yet we know that sexual predators seek out those employment opportunities as it gives them access to children. On behalf of the Frederick County State's Attorney's Office, I urge this committee to send a clear message to Marylanders that we will protect our children and hold sexual predators accountable by issuing a favorable report on SB 49. Thank you.
Excellent. Thank you very much. We'll now move on to Ms. Proctor. Sorry, go ahead.
There we
There
go.
you are.
Good afternoon again, Mr. Chairman and the committee. I am testifying in support of Senate Bill 49 on behalf of MSA and Richard Fritz, State Attorney for St. Mary's. I am a current prosecutor here in St. Mary's. I've also prosecuted in Charles County, focusing on the sex crimes of children. Along with Ms. Feinstein, I have had experiences in cases, most recently here in St. Mary's with 2 music teachers who were privately employed. One worked out of his home. The other one had a local business suite here. Parents would sit on the other side of the door, wait for their child to finish the music lesson, and had no idea that behind that same door, their child was being sexually abused. One victim was 8 years old. One victim was 12 years old. The loophole that has been created really needs to be fixed. Under the current law, if you're lucky enough to get past the consent issue that the 4th degree brings and still can charge it, that's a 1-year maximum offense. Where the 3602, the sexual abuse of a minor, is a 25-year offense. There should not be a difference just because who the teacher is employed by, whether it's private or a public school or government entity. The children, the victims of these crimes, it should be equal to both, whether it's a private employer or the public employer. And I ask for a favorable report for this bill. Thank you very much.
Excellent. Thank you very much, Ms. Proctor. We'll now move on to Ms. Jordan.
Good afternoon, Mr. Chairman, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in support of Senate Bill 49. So there are 3 ways to go after perpetrators against children. Statutory rape, but once you turn 14, you can consent to fondling, and once you turn 16, you can consent to sexual acts involving penetration. So that leaves the 14 to 17-year-olds vulnerable. You can prosecute under sexual abuse of a minor under 3602, as some of my colleagues have already described. The difficulty there is that you must prove that someone's a family member, a household member, or someone who's in care and custody of that perpetrator or under the supervision of that perpetrator. Or the law that you're seeking to amend right now, the person in authority. And the person in authority, that applies regardless of whether the child is under care and custody or under the supervision. So let's go back to Ms. Feinstein's example. The dad was sitting in the anteroom outside the guitar lesson. And so that made a question about whether the child was really in care and custody of that guitar teacher. So that was off the table for her. And then for the person in authority, the blanket prohibition, that guitar teacher didn't work for a school. So that didn't work. And the child was 16. So statutory rape didn't work. The thing that I want to say from the Maryland Coalition Against Sexual Assault is that from the kid's point of view, that's crazy. None of that makes any sense at all. She is feeling just as exploited. She is feeling just as traumatized. She is feeling just as failed by the criminal justice system as she would if the teacher were employed by the school, or she were 15, or or there was some other theory, but this little tiny remaining loophole is really leaving kids without protection for no good policy reason. Now, I've worked, as Mr. Schellenberger has, for years on this issue, and I can tell you that that one of the things that I wanted to bring to your attention is that the perpetrator needs to be over 21. Right. And so that is there because we want to make sure that we're not interfering with people where one person just graduated from high school and they're 19 and the other one's 17. That's not the scenario. These are people who are in authority over these kids, and they're at least 21. So for those reasons, the Maryland Coalition Against Sexual Assault asked for a favorable report on Senate Bill 49.
Excellent. Thank you very much, Ms. Jordan. And we'll now move on to Mr. Apple.
Thank you, Mr. Chair, Mr. Vice Chair, distinguished committee members. Good afternoon again. My name is Chris Apple. I live in Columbia. I'm testifying today to ask you to close this loophole in our criminal laws. I have been an officer in a community orchestra in Montgomery County, and I have given people private music lessons. I've also been in charge of teenage interns at work and of teenage volunteers with a youth-oriented nonprofit organization. That student mentor bond can be a huge source of strength and help those teenagers find confidence in themselves. And it can teach them skills that give them a leg up in the future. And it's awful to listen to the stories today about the people who would abuse that bond. I understand from previous year's testimony that this is a common occurrence and it keeps happening. And my concern is that the longer we wait to close this loophole, more people will be able to abuse these teens without being punished. So I'm hopeful that this is the year that we can pass this legislation. I'm concerned that if abusers realize this is legal, they may feel empowered to strike again. And I don't want Maryland to be a place where that can happen. So please, I'm asking today the committee issue a favorable report for this bill help close this loophole, help keep our teenagers safe. Thank you very much.
Thank you very much, Mr. Apple. And with that, that'll conclude the testimony for Senate Bill 49. We'll switch to the committee for questions. I see Senator Sidnor and then Senator Hedelman. So Senator Sidnor, you're up first.
Thank you. I just had, I had two questions, but Ms. Jordan answered one of them. So the other question I had on page 3, line 10, there's an exception. It says except as provided in 3-307A4 of the subtitle and subsection B2 of this section. A person in a position of authority may not engage in a sexual act, sexual contact, or vaginal intercourse with a minor who. The question that I have, and I'm asking any of the our prosecutors who have testified, is the addition of vaginal intercourse. What is the purpose of having that specific language added when I guess I would think vaginal intercourse would fall under, be included in a sexual act or a sexual contact. So when I see the vaginal intercourse, I'm wondering, well, could that be read or interpreted that that particular section would then no longer apply to young men? And
would you like to answer that question? Let's go to the sponsor and then go to Ms. Marsh. I think.
Sure, that works.
Yeah. So Senator Sidner and I have think very much alike. I asked exactly the same question of Scott Schellenberger last week. Scott, were you there? Did you hear the question? It was Senator Sidner wonders about the differentiation between sexual act, sexual conduct, and vaginal intercourse.
So I did hear the question. Thank you, Chris. Maybe one of my specialty assistants can weigh in on this. I don't know if this is a vestige of the old laws where we distinguish between vaginal intercourse, a sexual act, which was a list of things, and sexual contact. They had 3 different definitions, and this might be a vestige of that. I see Ms. Marsh shaking her head and Ms. Feinstein. I'd be happy to defer to the expert.
That works. Thank you.
That is absolutely what this is. When you look at the definitions under the sexual crimes, so 3301, and it does go back to when we used to have a second-degree rape and a second-degree sex offense and a first-degree rape and a first-degree sex offense. We define them differently. And so vaginal intercourse was defined separate from a sexual act. And so as the bill is written, though, it does include a sexual act. So our young men are not left out. Anybody with oral sex is not left out. The way we have it, it does include every kind of sexual act penetration that would be committed against a minor. But that's just why it comes back to our old definitions where we have vaginal intercourse defined separately than a sexual act.
And just out of curiosity, would cleaning up the statutes that and the language be an easier way to go, or do we continue using that old language? I'm just asking what you all think. This is Ms. Marsh as well.
I don't know if Ms. Marsh is muted. I'm happy to answer as well. Ms. Marsh, are you muted?
She's unmuted, yep.
I was going to say, go ahead though, Debbie, please.
I was going to say, we defer to you. It would definitely require changes in a number of different statutes to change, to make vaginal intercourse defined as a sexual, to define it as a sexual act. It really is just a vestige, but of the prior statutory scheme. But, either way, we just want to make sure that a person in position of authority, 4th-degree sexual offense, is in parity with the, all of the definitions are included.
Thank you very much for your answers. Appreciate it.
Thank you very much, Senator Sidnor. We'll move on to Senator Hedelman.
Thank Thank you very much, Mr. Chairman, and thank you, Senator West, for bringing this. I think it's a really important bill and really important in closing loopholes out there. My question, I guess, goes to one of the things that Ms. Jordan said, and she was talking about the adult is over 21. And I'm just wondering, so you could have a 21-year-old or 22-year-old, let's say, for argument's sake, who's giving music lessons to a 17-year-old, and they would be captured under this. But if the minute the person turns 18, they're outside of the purview of this. Is that, am I understanding that right? Because they're now the age of majority?
Yes, you are understanding that correctly. I will say that over the years, we've looked at any number of variations on that, including requiring a larger age gap, and people had great concerns about that. And I think that the idea that once you do turn 18, you're no longer a minor, so would no longer fall under this is something there seemed to be consensus about, but it's a very difficult issue. You know, adolescents are called adolescents for a reason, because they're both adults and children. And so this is a balancing act for sure.
Right. And Senator Helderman, if I could weigh in, Ms. Jordan and I have testified numerous times about age differences, and I do very much remember getting questions about 18 and 15 and how close that is together. And so we were going for a place that we felt would be a good dividing line.
Namely 21.
21.
Okay. I understand, and I get it. It's just you know, some of these older teens are like still in high school. And okay, well, thank you.
Thank you very much, Senator Hedelman. We'll now move on to Senator Castley's question.
Thank you. I support the bill. I had just a question on the very last line of the bill. Actually, it's the bottom of page 3. It says, unless specifically charged by the state, a violation of this section may not be considered a lesser included offense of any other crime. Does that mean that you must specifically charge this and it's not a lesser, it cannot be considered a lesser included offense? And if that's what it means, maybe you should just say that.
Well, I think it does. The intent was to make absolutely certain that the defendant and the defense attorney are on notice that this was an option, because they could be thinking in terms of a traditional sex offense where they're looking at consent or lack of consent or some type of force, or looking at the age difference. And they wanted to make sure that in the drafting this, that it was absolutely clear that we had to charge this separately, unlike some other offenses that we normally don't have to.
Okay. Well, I mean, I'm not going to challenge the drafters. It just seems awkward to me that it says unless specifically charged by the state. So what that does mean, though, is this does have to be specifically charged, and it's not charged. It can't be considered a lesser included offense.
Right. So it couldn't be a lesser included of 4th degree.
Right.
It has to be specifically named.
Fully charged.
Yep.
Okay.
Yep.
Okay. Thank you.
So Senator Castley, if I can add, I believe it's also because of the extreme difference in sentencing available from sexual abuse of a minor. So that's up to 25 years.
Yeah.
And this, of course, as a misdemeanor.
Yeah. No, I don't disagree that it has to be specifically charged. I'm just, the wording of the thing just had me sprung that it was unless specifically charged. It just seems like what it really means is this must be specifically charged and is not a lesser included offense. It would just maybe that's the way they want it's written, but okay. I think we understand. Thank you.
Thank you, Senator Castley. All right, looking to the committee for additional questions. Seeing none, that'll conclude the hearing for Senate Bill 49. Thank you very much, Senator West, and to the panelists. We'll now move on to Senator Sidnor with Senate Bill 31. Senator Sidnor, you're up.
Thank you very much. And good afternoon, Mr. Chair and members of JPR. Senate Bill 31 should be familiar.
Senator Sidnor, I don't know what happened, but everyone got muted again. So go ahead.
Shall I start over?
Yes, please.
All right. Senate Bill 31 should be familiar with everyone. It's a bill that we all heard last year and we voted out unanimously. However, it ended up not getting through the process over in the House. And it's funny when I look at the history of this bill, when I was over in the House, we were able to get it through the House and not through the Senate. So it's passed both houses, but hadn't done so in 1 year to make its way to the governor's desk. What Senate Bill 31 does is it's a bill that addresses a vitally important topic, talking about the balancing of police body camera video footage and how it should be handled under the MPIA with citizens' rights of privacy. Back in 2015, when we passed the state's body camera legislation, as a part of that, there was a commission that was formed, and this was supposed to be one of the bills that came out of the ideas from that particular commission. Ensuring that things that were of political or public import made its way to the general public, but also while protecting a certain class of people who needed their own protection. There have been cases across the country where people who have been victims of domestic violence, rape, and other types of incidents have had their perpetrators access body camera footage and use that as a tool of harassment. So what this bill does is it takes away the discretion of the custodian so that they can, I believe, focus on those kinds of things that we want out in the public. It takes the discretion away so that when they have video footage that depicts victims of domestic violence, rape, or sexual crimes, victims of abuse, and even those that have the death of a law enforcement officer, and this was included a few years ago, and because I could reflect back upon the killing of my uncle's partner back in the 1980s, and obviously there was no body camera footage back then, but I recall watching the news, and the news continued to play the audio footage of his death when he was shot and killed in an undercover drug operation. So what this bill does is says, look, there's no discretion. These are the kinds of things that don't need to be released to the public. That is, unless the person who's the subject of that particular video footage wants to release it. So it gives that ownership to those people who are caught on video. I'm going to be quiet at the moment because I have some folk who can testify to some other aspects a lot better than I can. So I'll leave it there and ask that this committee again pass this bill unanimously. Thank you.
Excellent. Thank you very much, Senator Sidnor. So we'll now move on to your panel. We'll start off with Ms. Jordan.
Thank you, Mr. Chairman, Mr. Vice Chair, members of the committee. Again, I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in strong support for Senate Bill 31. Senator Sidnor, thank you for introducing this again, and you did an excellent job, as always, of explaining the bill. You know, camera images and audio in this sort of situation can include sexual assault survivors and other survivors of abuse in some of the most traumatic and difficult times in their lives. And really, we need to balance and take care to ensure that the justice system does not add to the trauma by publicly disclosing body camera footage. Keep in mind that rape survivors rarely seek help from the criminal justice system. There's little trust that the system is going to respond in a supportive way. And that for Black, Brown, immigrant, and poor and other survivors in marginalized communities, there's even less trust. And the current law is really making it worse. And it's unnecessarily disrespectful of survivors. It's out of balance. Imagine the case where someone does reach out to law enforcement and the survivor, perhaps bloody, bruised, perhaps partially clothed, and definitely traumatized, And all of that is captured on the body camera footage. And I'd call the committee's attention to the testimony from our colleagues at the Women's Law Center describing a particular case in great detail, talking about someone whose abusive spouse posted that footage, and how that the woman involved is now terrified to even call the police because she's afraid that she's going to be further humiliated by having this body camera footage up there. This is absolutely not a solution seeking a problem. This is a very real problem, one that's been discussed nationally, one that's been discussed from the onset of issues regarding body cameras. And body cameras, we believe that it's important to have this footage. It's absolutely crucial. But let's also keep in mind some things that this bill does not do. It does not change access in civil discovery. Does not, if I may just a couple more seconds, Mr.
Absolutely,
Chair.
yeah, this is good to keep going.
Thank you.
Good.
It does not change the rules permitting access to footage introduced in evidence in court. It does not limit the ability of a victim to see the footage for any reason. So that includes holding law enforcement accountable. If you have a victim who was mistreated by law enforcement, that survivor can get access to the footage. And importantly, it also does not prohibit alleged assailants from viewing the footage. It prevents them from copying it so they can't post it. And it requires the victim be notified that they saw it so they can do safety planning. So this is really balanced. And I have to say, it's offensive to think that somehow privacy is protected by letting county government employees go through this and figure it out and decide. We need to put that power in the hands of survivors. And so for those reasons, the Coalition Against Sexual Assault urges that this committee once again issue a favorable report on Senate Bill 31. Thank you.
That's very helpful. Thank you very much. All right, we'll now move on to Ms. Shapiro. Good to see you. Ms. Shapiro, you're up.
Good afternoon. Thank you, Mr. Chairman, Mr. Vice Chair, members of the committee. My name is Melanie Shapiro. I'm the Public Policy Director with the Maryland Network Against Domestic Violence. SB 31 carefully balances the interests of victims of certain crimes, including domestic violence and sexual assault, with the need for greater police transparency. To be clear, MNADV supports police transparency because approximately half of all domestic violence incidents go unreported. This is for reasons including a desire for privacy, fear of reprisal, as well as mistrust of the police and not being believed by the police. In a 2015 ACLU study on why victims of domestic violence and sexual assault do not call the police, nearly a quarter, 24%, said that police sometimes use inappropriate violence against the victim. However, we need to ensure that the proper policies exist for the release of body-worn camera footage. While current MPIA law allows for the discretionary withholding of footage that is insufficient, who is viewing the endless hours of footage? Who makes the decision to release or not, and to whom? Are these the same people, the neighbors, friends, or colleagues of the victims? The Fourth Amendment bestows upon citizens a reasonable expectation of privacy in places including their home. When an officer responds to a call for domestic violence, they often enter that protected space with audio and visual recordings on. It is possible that a neighbor called the police. The body-worn camera should be on and recording, but they should not become a public record for anyone to access, such as that neighbor that called the police. In addition, there's a really serious issue of victim safety. When police respond to domestic violence calls in Maryland, they may perform a lethality assessment and connect that victim to shelter or services, arrange for a safe place for the victim to go. All of this may be released without SB 31, including the answers to the lethality assessment, which could place them at even greater risk by their abuser. Victim safety can be compromised, their location shared with anyone who has the body-worn camera footage, and confidential shelter locations can become public. This bill is carefully balanced the needs of victims of domestic violence, those of confidentiality, privacy, safety, with the need to develop trust and confidence in the police. For all those reasons, we urge a favorable report on SB 31. And if I just may add, I would note to the committee that Senator Sidnor was the champion of the body-worn camera bill last session that required all public-facing law enforcement be outfitted with body-worn camera footage by 2023. And similarly, he is balancing that with SB 31. And so I'd like to thank Senator Sidnor for this bill.
Thank you, Ms. Shapiro. We remember well. I know that Senator Sidnor has been a champion even when he was in the House, so thank him for his work. All right, we'll now move on to Mr. Nyber. Good to see you again.
Good to see you too. Thank you, Mr. Chair. Mr. Vice Chair, members of the committee, my name is DePaul Nibber. I'm representing the Maryland Association of Counties in support of SB 31. This bill is a former MACO initiative and is needed now more than ever. Under last year's Police Accountability Act, all county law enforcement will be required to have body-worn cameras. With unprecedented amounts of body camera footage available to the public, a balance, I think you've heard this theme through all the testimony thus far, it needs to be struck between police accountability, the privacy and safety of victims, and government resources. This bill addresses all these potential issues. Footage related to arrests and potential law enforcement misconduct, as you've heard, it will still be available. Victims will be unequivocally protected. There shouldn't be a discretionary element to whether or not this footage is actually released to the public. Moreover, privacy will be protected. Again, there's a discretionary element here with regards to its release that shouldn't exist. And then finally, government resources are going to be protected. As mentioned in our written testimony, a single request for body camera footage could cost thousands, if not tens of thousands of dollars in attorney review and other administrative costs. This in and of itself could derail a number of local body camera programs. Altogether, SB 31 is needed to ensure police accountability, the privacy of Marylanders, the safety of victims, and the protection of government resources. We urge a favorable report.
Awesome. Thank you very much. All right, we're going to go a little bit out of order. We've I know we're going to switch over to the opposition panelist. Mr. Roca, you're here. I know you've got an obligation to attend to that's time sensitive. So go ahead and testify now, and we'll hop back into order.
Thank you very much, Mr. Chairman. Appreciate you letting me go out of order. Mr. Vice Chairman and members of the committee. My name is David Roca. I'm a senior staff attorney with the ACLU of Maryland, here to urge an unfavorable report on SB 31, absent a key change. Versions of this bill have been repeatedly rejected by the General Assembly in 2016, 2017, 2018, and I think for good reason. SB 31 seeks to establish special rules governing the inspection of body-worn camera footage. There's no doubt that body-worn cameras will capture video that should not be released to a third-party requester, but Maryland's current Public Information Act provides ample authority to law enforcement agencies to deny access to those parts of recordings that all would agree should not be released, including specific protections to protect privacy, witnesses, etc., a great many of which are not even addressed by this bill. And despite such footage having been available for many years now, I'm not aware of a single problem of footage being required to be released anywhere in this state. The bill creates two categories of body-worn cameras that must be withheld. First, any records that depict victims of various crimes or the death of police officers must be redacted pursuant to, I'm going to leave out the statutory sections. And second, the bill requires that the request for every other body-worn camera must be denied unless the record fits within exceptions established in the bill. That section seeks appropriately but incompletely to carve out various categories of police behavior that would not be prohibited from disclosure. And the key problem is that that list is not sufficiently inclusive. It omits the myriad police directives that people must do or not do a particular act when the directive is not accompanied by an arrest, detention, search, use of force, or injury, such as improper questioning, orders to move along, cease panhandling, all of which are a frequent source of police community tension. Being able to document this conduct is crucial and one of the key reasons to have body-worn cameras in the first place. For example, the ACLU requested body-worn camera video recorded by officers working in Harlem Park during the unprecedented lockdown of that neighborhood. And the city would, and in fact did in the lawsuit that we filed as a result of getting those videos, argue that none of those encounters were detentions because simply living in the neighborhood or trying to visit someone there was not a lawful basis for a detention. And if this law had been in effect, none of those videos would have been released.
Mr. Roca, if you could conclude briefly, you're a little over your time.
Yeah. The other categories of videos that have to be withheld, the problem is that by trying to create a categorical definition, life doesn't fit neatly into the categories that are being defined here. So, for example, a tragically recurring occurrence is for someone to call the police because a family member who suffers from mental illness is acting erratically or violently. And when the police arrive, rather than de-escalating the situation, they injure or kill the family member. The person, the caller in such cases will often fit the criteria of a victim
Mr. Roca,
under this bill, and that would then prevent the video from being withheld. Categorically, no discretion. And the solution to this is to
Mr.
not
Roca,
say shall release, shall withhold, but to say may. With
Right.
that one fix, our opposition to this bill would go away.
Excellent. Thank you very much. All right. Now we'll move back to the proponents of the bill, and we'll go on with Mr. Fitzgerald. Mr. Fitzgerald, you're up.
Thank you, Mr. Chairman, Mr. Vice Chairman, members of the committee. Can you hear me all right? Okay, thank you. My name is John Fitzgerald. I am the Chief of Police for Chevy Chase Village, Maryland, and I'm here on behalf of the Maryland Chiefs and Sheriffs, and we urge a favorable report for Senate Bill 31. I've worked with Senator Sidnor going all the way back to the work group for body cameras for the governor's office, and subsequently on several bills, including this one. This bill is remarkably easy to get behind. This is so simple and so necessary. I've been doing this work for over 38 years, and I've been an attorney in Maryland for over 30. And this one screams to me for as one of the bills that is just sound policy. It does three things really, really well. Number one, it protects all those special victims that you've heard described by my colleagues here, the people that we want to really protect because of the sensitivity of their victimization. That's number one. Number two, it provides all Marylanders with privacy protections from voyeuristic people that want to see things that aren't really important, but really invade the privacy and sanctity of someone's home when they're in crisis. It could be an argument with their teen that's in some sort of crisis. It doesn't have to be a sexual crime, but there's a lot of private things that cameras like this will see that dashboard cameras simply will not. The third thing it does is it still enables a tremendous amount of transparency for the public to see what the police are doing. It lets Marylanders see all of those things that are important to them that police may do. Uses of force by police, video that captures a search, arrest, detention, citation issuance, an injury of somebody, or any event. Any event where there is a complaint of police behavior. That's such a broad category that will take care of what Mr. Roca is concerned about. I want to remind the committee that last year, not only did you return a favorable report unanimously, it passed 45-0 on the floor of the Senate. And it wasn't rejected in the past, as Mr. Roca mentioned. It passed 130-8 in the House in 2016 and 133-3 in the House in 2017. It just didn't make it across the aisle. It's been accepted with broad support in both houses.
Thank you very much, Mr. Fitzgerald. Thank you. All right.
Thank you.
All right. We'll now move on to Mr. Kroll. You're up next. Let's try this one more time. There. One more time. You had it for a second. There you go.
Mr. Chairman, can you hear me?
We can. It's very low. We can hear you.
All right, I'll stand closer. Good afternoon, everyone. It's great to be heard. I just want to make a record, Mr. Chairman, that I'm on the same side today for Senator Carter and Senator Sidnor. So we do stand sometimes on bills with them. So I want to make that reflection for the record, please. I'm Stephen Kroll, the State's Attorney Coordinator for Maryland, Executive Director of the Maryland State's Attorneys Association, and I've been prosecuting cases for over 38 years. And we are here in support of Senate Bill 31, and I'd like the committee to look at Rich Gibson, the State's Attorney for Howard County, and the President of the Maryland State's Attorneys Association, written information that he sent to the committee on January the 17th, 2022. We are in support of this bill. I know Senator Sidnor and Mr. Gibson have had conversations with each other. We are asking for one amendment. We strongly encourage and have already discussed with Senator Sidnor in expanding the protections of Section C2, specifically to include the prohibition of sharing body-worn camera video at all. And its purpose is not to give body-worn camera out while an investigation is going on. We think it's appropriate not to do that while we're conducting an investigation. And that's something that we have discussed with Senator Sidnor. Our second concern is that the burden that's placed on the custodian of records to give information out, that custodian may not be trained properly, may give out information that is not appropriate. So we have to be concerned with who the custodian is and what they're giving out at that point in time. Given those two concerns, the Maryland State's Attorneys Association and our 641 members is in support of this bill with those two amendments, or really one concern. We look forward to working with Senator Sidnor, and we thank him for his efforts in this case. We ask you to read the Honorable Richard Gibson's note to this committee on January 17th, 2022, and I'm happy to answer any questions. Thank you very much.
Thank you very much, Mr. State's Attorney. The next to testify will be Hillary Woolley from the City of Baltimore. So if we could unmute Ms. Woolley from the City of Baltimore. Give us 1 second here while we work out our technical difficulties. All right, Ms. Pop.
Yeah, sorry, I had a call, so I did not hear what you said. What are we looking for?
No worries. We're looking to unmute Ms. Hillary Woolley from the City of Baltimore.
Okay.
Can the committee hear me now?
Yes, we can. Go ahead, please.
Great, thank you. I'm Hillary Woolley. I'm the Chief Solicitor in Baltimore City's Law Department, here to convey the city's support for Senate Bill 31. And it would guarantee the victims of sexual crimes, domestic violence, as well as children and vulnerable adults that are victims of abuse, when they call the police for help, their body camera video showing their discussion with that officer won't be given to the perpetrator or the public to be put online.
Okay, can you tell Terry that she needs to make Welch Stryker a co-host?
Thank you. Go ahead, Ms. Woolley.
Sure. Right now in Maryland, these videos can sometimes be protected at the discretion of the police departments if they're willing to articulate in writing why protecting the privacy of these victims is in the public interest. And this is frankly often more work than an overworked police staff or their well-intentioned lawyers can handle, because releasing the video doesn't require that kind of written analysis. Many other states recognize the unique privacy interests of these types of victims. And in fact, the National ACLU recognized the need for this type of protection in 2013 with an article they called Police Body Mounted Cameras. With right policy in place, a win for all. But they noted that win only happens if these privacy interests are, quote, carefully balanced by policymakers, end quote. And that's exactly what Senate Bill 31 does. It takes the balancing out of the hands of individual record custodians and lawyers like me and puts it in your hands as the policymakers. And to be clear, it doesn't impact criminal defendants. They don't need the Public Information Act to get evidence for their case. They can still use the criminal discovery process. And as you've heard, the bill's narrowly tailored. It does not affect any of the videos that Mr. Rocha or others claim, and we all agree, need to be seen by the public. Any attempts or at arrests or detentions, anytime anyone's cited, any death, any injury, anytime the police are subject to a complaint. This bill doesn't change anything about the current process. And I would just urge the committee to think, don't allow anyone to silence these victims by claiming that they are not aware of any issues where this bill is needed, because we know that coming forward as victims who need this bill would violate and impact the very privacy we're seeking to protect. These victims can't come out publicly without suffering these kinds of consequences. And that's why national organizations like the National ACLU, the Battered Women's Justice Project, and all the people you have heard today have to speak for them. And this is why the city of Baltimore has supported this enactment since body cameras became widely used, and it urges a favorable report on this bill. Thank you.
Thank you, Ms. Ruley. And if you could send the committee the National ACLU article that you referenced, I think that would be helpful to have for our files. I think the final witness is in the unfavorable position. That's Ms. Snyder. Ms. Snyder, please go ahead. Yep, Ms. Snyder, you are on mute. If JPR staff could please unmute Rebecca Snyder from the MDDC Press Association.
Okay, thank you very much, Vice Chair and members of the committee. I'm Rebecca Snyder with the MDDC Press Association, and we urge the committee to reject this, this proposal because it does diminish the Public Information Act. We actually don't have any issues or concerns regarding sensitive footage around domestic violence survivors, vulnerable adults, children, and things of and that element of the bill, but specifically sections B, 4, and 5 do create large swaths of body camera footage that we feel like are already very difficult to receive from a news gathering perspective. They're already, as we look at the implementation of Anton's Law, which the legislature passed last year, the bills coming in to view footage and documents under that law are just really large, and it's difficult to get these tools of accountability. And so further erosion of the Public Information Act is deeply concerning to us. And so the large categories that could be shielded, we think are of concern. And there are protections already under the Public Information Act, which allow custodians to shield enormous parts of the public record and body-worn camera footage. And so distasteful or difficult, very sensitive things can already be shielded. And we feel like this is just an erosion that creates more problems. And so we would want to take out section 4 and 5. That would eliminate our concern with the bill. Barring that, we urge an unfavorable report. Thank you.
Thank you so much, Ms. Snyder. Looking around the Zoom room, it looks like Senator West has a question. Senator West, go ahead, please.
Thank you, Mr. Vice Chair. I just am confused by language at the bottom of page 6. There's subparagraphs 2 and 3, and maybe somebody who's helped to prepare this bill can explain them, as particularly subparagraph 2. It says a custodian may not allow inspection or copying of a recording from a body-worn camera by an individual who is under investigation for or is charged with a violation described in subsection B if the recording is of the incident leading to the investigation or charge. There's a general principle of criminal law that if you're charged with something, any possible exculpatory information has to be provided to you by the prosecutor. So assuming that there's an investigation of a law enforcement officer, I would think it would be required under our criminal laws for the officer to be provided with any body camera footage which relates to what's being investigated. Am I wrong on that? Am I reading this incorrectly? Who knows how to answer that question?
So I think the preference here is that you direct it to a specific person, but sort of that.
Well, let's see. When Mr. Kroll came out in favor of the bill, so could you explain this paragraph and why the State's Attorneys Association is in favor of this?
I will let Chief Fitzgerald speak first and then Ms. Ruley, and I'll go third. How about that?
That sounds good.
Yeah, so I think what we'd like to do is one question, one answer. So Chief Fitzgerald, why don't you go ahead on this one, and then we'll take other questions.
Sure. Thank you, Senator West, for the question. The purpose of that language is to make sure that the Maryland Public Information Act does not serve up this material during the investigation. None of that information ever goes out under any criminal investigation to the subject of the investigation while it's ongoing. It is certainly something that is required to be given to them under criminal discovery rules. That is where it will go to them prior to trial, not prior to the charges and not during investigation.
Well, I gather, I understand that, but this language says they're not allowed to get it either during the investigation or if the person is charged with a violation. So
Yes, yes.
So when I'm charged with a violation, you're saying I'm not permitted to see the body camera footage on the basis of which I'm being charged?
Correct. Not under the Maryland Public Information Act. This modifies the Public Information Act. It will go through the discovery process. So we don't want the Public Information Act to be abused as a vehicle for discovery.
Okay, I still don't understand. So the rule will be that if I'm a police officer and I've been investigated and I've been charged with a violation on the basis of body camera footage, I'm not going to be allowed to take a look at the body camera footage, which is the basis of the charge.
Hillary, why don't you pull it up from here?
Yeah, let's let Ms. Woolley take a crack at this.
Okay.
Hi, yes, no, that's wrong. All
Oh, good. I was hoping you'd say that.
Yeah, no, all of the criminal laws are still in place. If you're the one charged, of course, you get the video. This pertains only to the Public Information Act, and the law itself is actually clear on that. It says that up in sort of, I think, let me find the exact language. It's in 4-357A2. So page 5, lines 7 through 9. This has nothing to do with your ability to get it when you're defending a criminal suit. Nothing. This is applying only in the context of the Public Information Act. So if you are not going through your criminal process, if you haven't been charged any of that. And so the reason it says at the very end that you can't allow inspection, the custodian, of a recording by an individual who's under investigation for or a violation described in subsection B is because this is about those people who are committing the crimes, the perpetrators of the domestic violence, the sexual assault, all those people who are being investigated. They don't yet have their criminal process, but they're being investigated. They can't get a copy of the video and shame the very people who are going to need to testify against them. That's sort of the whole point.
Right, so this is not stopping police from getting video if they charge. It's stopping.
Has nothing to do.
It's stopping perpetrators of sexual violence against women from getting.
Absolutely, as well as against children and other vulnerable adults. And once they are charged, their whole criminal process is exactly the same. It just prevents them from shaming the victims during the investigation, threatening to put this out online if their victims go forward with prosecution.
Okay. All right, gotcha. Thank you very much. It was helpful.
Thank you so much, Senator West. Are there any other questions from members of the committee? Senator Carter, you look like you have a question. So go ahead, Senator Carter. We'll wrap it up with your final question here.
I do. It's just that my hand color blends into the background, so it doesn't jump out as much as the yellow hand. So trying to figure out the bill and the real need for it. And I'm wondering if any of the proponents of the bill can point to any specific examples where this has been an actual problem.
All right, let's go with Ms. Shapiro. Go ahead, please.
Thank you. Hi, Senator Carter. Thank you so much for the question. I would direct you to the testimony of the Women's Law Center. I believe Ms. Jordan mentioned it in her testimony as well. And they outline a particular situation where a victim of domestic violence had her abuser obtain the body-worn camera footage. If you go actually to the Baltimore County Police Department website, there's a form you fill out to get the body-worn camera footage. And this individual was able to obtain it and placed it on social media and continued to perpetrate their abuse against their victim, having access to that body-worn camera footage and embarrass them very publicly with that. So that's a very real active case going on right now in Maryland.
So when you say abuser, that person was a criminal defendant that would have had access to the information anyway?
I don't know that he was, I don't know whether or not he was criminally charged. I know that there were custody proceedings for which the Women's Law Center was representing the individual, and the testimony outlines the specifics of that case. The individual contemplated actually testifying in support of the bill last session, but decided it was too personal and was too impacted by the situation to testify publicly. So the Women's Law Center has shared her story.
So that is, yes, Mr. Kroll. Oh, I'm sorry, not for me to call on you. Normally we say one person, one answer, but if the vice chair says so, I'll let you speak.
We'll try to keep it to that generally, but go ahead, Mr. Kroll.
Thank you, Mr. Vice Chair. Thank you, Senator Carter. My concern is this is a public testimony right now. And good news travels fast and bad news travels fast. And once perpetrators find out it is available to them, look out what's going to happen. So Senator Sidner's bill stops it right here and right now. That's why we need it. This is public information. I'm afraid anybody can tune in and get information that they may not know about at this time. So I know Ms. Jordan has a case. I knew about that, but I'm also worried about the future.
I understand. So I do have some concerns. I haven't spent a lot of time grappling with the bill and all of the potential scenarios, but I do think that it might require a closer look. I understand the intent, but I do have concerns about transparency and I'll look at your example as well, but you know, in my experience, I've generally seen victims and persons that shouldn't be exposed to the public be redacted in release of information. And so I'm thinking that's the norm, that they aren't usually just putting people out there and that are vulnerable. So I'd like to take a further look at it and possibly work with Senator Sidnor on if it requires any additional, modifications or amendments.
Thank you, Senator Carter. Good point, important point. Senator Sidnor, you had a question.
If maybe Ms. Jordan, if you wouldn't mind speaking to that point about redaction and why redaction may not be sufficient.
Yes, thank you, Senator, for that question. I think that part of what we need to do when we're talking about public policy is encourage survivors of these crimes to come forward and make sure that all survivors, regardless of their privilege, their background, their skin color, have the same ability to trust government, trust police. And the idea of saying to someone, oh, we'll redact your face after you've been raped, I think is really, it's very cold comfort. You may have people in their homes where they can identify the entire home. You may have people who they have a child in the background. You may have redaction software generally targets, someone's face, but it may be that someone is exposed otherwise. And redacting really doesn't address the point of, in small communities, you often have people who would be doing the redaction who actually know the victim in that case. And so just the redaction process itself is extremely invasive. I do want to be absolutely clear that MCASA fully supports body cameras. We fully support police accountability. Senator Carter, in that sort of case that you're talking about, if it was a criminal defendant, all this bill does is it limits the criminal defendant's ability to copy the body camera. They would still have access to looking at it. They would still be able to conduct criminal discovery. And Senator West, to the kind of the second part of your question about the language regarding people at PBJs and that sort of thing. If you look at it, it also is like, you cannot copy that footage, because we all know that many domestic violence cases are not ultimately prosecuted. Many sexual assault cases are not ultimately prosecuted. So if somebody has a PBJ, for example, we don't want to allow the perpetrator to copy that footage. So it really is balanced. And certainly Senator Carter, any of the members, if you have suggestions about how to appropriately protect government accountability, we are very concerned about that issue as well, both in general for our society and for improving our criminal justice system, but also because victims of crime get some really terrible responses based on their background, their race, being Black and brown, being poor, being immigrant, and we need to make sure all of this is balanced. But allowing footage, even redacted footage, is going to discourage people from coming forward.
Thank you.
So then I was just looking for it and I found it because I thought that we had done something to address this before, and we did. There was a bill from 2019, Senator Kagan, that we passed that allowed for a victim of domestic violence to have part or all of their record, to be notified about the request and to have part or all of their record shielded or denied. And so your position is that is not adequate. The law that we already have in place is not adequate.
Certainly it was a good start, but it's absolutely not adequate. And it is unfair to burden traumatized rape victims or child abuse victims or survivors of child sexual abuse, domestic violence with that sort of responsibility. Instead, we should have this automatic protection for those survivors, and also all of the protections that are inherent in civil proceedings, criminal discovery, civil discovery, allowing people who are charged to see these images. So there is a lot of access. What there is not in this bill is there's not placing the burden on survivors.
What about the weird, odd scenario where the person actually wants, the alleged victim actually wants to have the situation made public? They, something's happened to me and I want the world to see this.
Absolutely. And this bill gives them control over that because they would have access to it. They would be able to copy it. It would be the alleged perpetrator would not be able to copy it.
All right. Thank you, Senator Carter. Thank you, Ms. Jordan. Senator Hedelman has a question.
Thank you, Mr. Vice Chair. I wonder, and I guess I'll direct this to the sponsor, if you had a chance to look at the Attorney General's testimony and their concern about law enforcement officers who are involved in the death of a civilian, and whether you've had a chance to look at their amendment. And if not, we can talk about it later. But I just wondered if that was, I totally understand what you're trying to get at here, and I'm fully supportive of that. But the other issues and perhaps unintended consequences, and I just wonder if you had a chance, what your thoughts are on that.
I saw it, but haven't had a chance to digest it as of yet. But
okay.
I will be taking a look.
Okay, thanks.
All right, thank you all. I believe that concludes the hearing for that bill. Thank you so much, everyone who testified on behalf and in opposition to that legislation. We'll go now to the final bill of the day, which is SB 26. This is actually my bill, so I'll just take this on from this position, if that's okay with you, Mr. Chairman. SB 26 is a non-substantive technical fix. Senator Carter and I, and really Senator Carter has been the lead on this, have worked for many, many years to provide a second chance and expungement opportunities for people, especially those with non-convictions on their record. And last year, working with Senator Obie Patterson, we passed a revolutionary legislation that allows for the automatic expungement of all non-convictions. And that bill passed unanimously and bipartisanly. As many of you know, the books behind us and so many of these Zoom boxes that we have here are not published by the state. They're published by third-party publishers, and third-party publishers add little titles before the legislation that we've passed, before the laws that are in these books. Those titles are not substantive law, but they do give people looking at that law a hint as to what we were attempting to do. And judges see them too. When judges are ruling on the laws that we pass, judges see the headings that are added by third-party publishers. Staff was alerted to the fact that the bill that we passed last year was being misinterpreted by a third-party publisher, and that the best opportunity to resolve that would be through a technical, non-substantive fix. And that's what the bill in front of us does. It is a simple rewording of what we did last year to make clear what our intent is so that the third-party publishers appropriately categorize the law. And that's all the bill does. With thanks to council for bringing this to my attention. Mr. Chairman, that's all on this bill. I ask the committee for a favorable report. So I think the chairman may not have been made host. Seeing no questions on that, that concludes the hearing of Senate Bill 26. And Ms. Pop, unless I am mistaken here, I think that concludes our hearings for today.
No, you are correct. I did try to, I think he is now unmuted.
The mutiny. All right, got it. All right, thanks, Vice Chair Walsh. I think that's it. We're done for the day. I'll see y'all later.